For orders, item number 1.
May I please, your lordship?
Yes,
In this case, records were called for earlier, lordship.
records have been received. Okay,
Yes, lordship.
record have been, record have been received. Record
Yes.
LCR,
Yes, lordship.
only 1 or 2.
In this case, it was an ex parte order, lordship.
Ex parte order. Ex
Yes,
parte
sir.
order by whom?
Ex parte order by the learned tribunal. And
Then,
thereafter approached this honorable court, and this court has dismissed.
why is the dismissal
The
order?
dismissal order is at page, starts from 51. Relevant portion is at page 52. His lordship, petitioner belongs to the Nepali community and would like to rely upon the Indira Nevar's judgment, lordship, that she is not from the specified territory, lordship.
Yes,
Lordship, and I have annexed that Indira Nevar's judgment of this honorable court,
yes.
passed by this honorable court,
Please,
page lordship. Page 63, lordship. Where this honorable court has held that the person has to be from, its 60th tribunal has to come from the specified territory. Here, the petitioner had.
yes, Mr.
Not come from the
Paying, what to do?
My lord, if your lordship go through, the India Never case was decided on 29/11/2019,
Correct.
and the order of the honorable court, my lord, in earlier case was 5/1/2021, months after the my lord India Never case,
Yes,
and
yes.
it is not that, my lord, it is not the case that my lord not the case of this that the plea was not there before the my lord court. That plea was there, my lord.
But plea was considered.
Yes, my lord.
Where is it?
My lord, page 61, last part, it is, my lord.
Page 61.
My lord, the entire, it is discussed, my lord, the entire provision has been discussed.
No, 61,
No, my impugn order is that we start from.
61 is allowed. 61, it helps her.
Yes, lordship,
it-
yes, these are the judgment.
The
which I have.
impugn order is page 53.
51. Yes,
Page 53, there is no discussion about that.
yes, lordship.
So by default, because of correct, then the a person of Nepali, see Gorkha or Nepali,
Yeah, Nepali, lordship.
Nepali origin, he will be declared a foreigner by default.
So if it is not, my lord, the first of
It
all,
was not considered, it was not discussed.
it was not even, that could not, probably that was not pleaded at the time.
Correct. Now,
secondly,
see,
my-
correct, that is correct.
Yes.
What you are saying is so correct, but then there is nothing to indicate it has been considered. But now because of that, will he become a foreigner? That's the thing.
My lord, the legal position is that, my lord.
Correct, legal
Yes,
position also, but you
yes,
see the
we-
realistic
we-
position also. What is the
my lord.
realistic position?
We cannot go beyond the legal provision, my lord.
But that is what is wrong with that if we remand it?
No, my lord, the problem is that, my lord, they did not take the plea in the, my lord, it will come under constructive adjudication.
That plea, that
That will come under
specified
constructive adjudication.
in the writ petition, it's
If
there. lordship.
adjudicator is applicable for in case.
See, when the tribunal's order, when the-
2012, lordship.
2012, at a
Yes,
time this Indira Nevar order was not yet
Not there.
Yeah.
born. So therefore they would not know, they
No,
cannot
my
take
lord,
the
but
plea.
even in the High Court, they did not take plea.
But
because
High
this order
Court, there
was
is
not-
nothing that it was
Yes.
taken
No, they did not take, my lord, that's why I'm saying that the plea was
High
not
Court,
taken.
correct, High Court order was, correct,
Plea
High
was
Court.
not taken at the time of writ petition, my lord. Now they cannot take that plea, my lord. It will come under
So I have to
constructive
go to
res judicata.
specified territory.
If res judicata is applicable for them, constructive res judicata also applicable. And secondly, the issue, my lord, the matter was ex parte, my lord, there. So they did not, it is not that they raised that issue there, my lord. First of all, they did not raise the issue. Secondly, my lord, at the time of even writ petition, though the Indian Naval case was there, my lord, it was a settled position. They did not take the play at that time.
What is the tribunal's order?
Tribunal's order, lordship, is at page. Imperial order is at page 49. And if we see the inquiry report, lordship, LVO's report, whether migrated into Assam, it says no. No is ticked.
No, who prohibited them, my lord?
That plea has been taken in the writ petition, lordship.
If it is there, my lord, the order should reflect.
That plea was there.
If that plea was there, my lord, it should reflect in their order.
From the inquiry report is very clear, lordship.
Anything else, Mr. Bayang?
My lord, my point is that, my lord,
Yes.
first of all, they did not raise this issue in the writ petition, my lord. So at this stage, if they raise this, my lord, that point, it will come under constructive rectification. So no new plea can be raised under later stage. So secondly, my lord,
Yes.
in the tribunal, they did not appear to plead the fact. Plead, my lord, take the defense that he is not from, my lord, East Pakistan or.
Yes.
And hardly one issue, my lord, your lordship may consider. My lord, I admit, my lord, that my lord, principle of natural justice should be followed. In maximum, as far as possible, principle of natural justice may be given to the, my lord, petitioner. But it doesn't mean, my lord, in all cases, the principle of natural justice will lean towards the petitioner, my lord. In all cases, we cannot accept, my lord. In some cases, we accept it. Okay, it's okay. And my lord, my lord, just I want to read out, my lord, this is, last occasion I have submitted a judgment, my lord. This is, my lord, if your lordship, I have submitted 2 copies, but I don't have today, my lord. 2016, 1 GLT, my lord, 273.
2016?
1 GLT, 273. 273, my lord. Just, I'm
read out.
just reading out
Please
the
read out.
last one parameter.
Yes.
The principle of natural justice cannot, this is, my lord, in case of, my lord, foreigners tribunal, what happens? The principle of natural justice cannot be put into a straitjacket formula. It is more than 3 decades that the issue of influx of foreign nationals has been in the public domain in the state of Assam. Process of determination of question of citizenship cannot be one-way traffic, leaning only in favor of the person whose citizenship is doubted. Interest of the state is also of paramount importance in the unabated influx. has the potential to affect the integrity and sovereignty of the country. Citizenship of a person, no doubt, is a very valuable right and should be zealously guarded. However, if the person does not take the steps for safeguarding the interest, he does so at his own peril, my lord, which is the case in this case, my lord. Right to a fair hearing or principle of natural justice cannot be permitted to lead a facial situation and to be engine for defeating the very object of the identification and deportation of the foreigners. The petitioners had known about the allegation against them that they are foreigners entering in India with valid documents, at least for, my lord, this is in that case also, they knew it, they did not appear, my lord. So it was
Para number which you are reading? Which
para 16, man.
Para 16.
Yes.
But this is something else you are reading out and we are reading something else. See, this is something else. You are quoting some judgment, but this is reading something else. Para 16. Please see that this is the judgment. You cited 2016 1, GLT 273, no?
273.
But this is the one.
Yes.
This is the one. Please read para 16. Huh?
Yeah, principle
Okay,
of natural justice, para
But para 14.
16.
Para
My
14,
lord,
that
there
16
is
has
some-
been quoted.
Sorry, my lord.
Ah.
There are no.
We
my
have
lord.
considered the rival submission having so and so.
My lord,
For a reference, judgment is produced. Then para 16.
there are some
The citation
mistake in the my lord.
GLT
serial.
citation.
No. This is Ayubali.
Yes.
This is the one.
Yes.
Principal justice cannot be put in state jail in modern decade. Okay. This is the one. This is the one you are citing.
Yes.
Okay.
So, my lord, my point is that, my lord, obviously, it's a, my lord, guarantee, it's a valuable right. But it does not mean, my lord, they will always take the advantage of, my lord, the principle of natural justice.
Okay.
If they, my lord, come with clean hand, we have no problem, my lord. They had the my lord, opportunity to, my lord, defend themselves in the tribunal. They did not go. They had the opportunity in the writ petition to my lord, raise this plea. They did not raise. My lord, it's a judicial process, my lord. Judicial process must end. My lord, the object of this very purpose, object of this act, or purpose of this rule of, my lord, foreigners rule is that it should be, my lord.
Okay, very well. Mr. Payeng, do you agree that Indra Nawar case otherwise is applicable in the present case because this gentleman is from
My lord,
Nepal?
In fact, my lord,
On that issue,
yes,
forget
my lord,
about
yes, my lord.
if he is a Gorkha,
Yes,
if
my
he is
lord.
a Nepali, will it be applicable? Will Indra Nawar be
My lord,
applicable?
That's why, my lord, I am submitting. Though I was an arguing counsel in that case, my lord, but I differ from.
No, let us forget about your personal
no,
opinion.
no.
Let us do what the law says.
What the law says, my lord, your lordship may kindly say, this law, the only point was that.
Let
my
us
lord,
not argue Indra Nawaz,
no,
re-argue
in
Indra
the
Nawaz.
present
Let
case
us
also,
take.
in the present case also, my lord, if they says they are not comes under, my lord, that provision, the, my lord, 2009 rules, they are relying that 2009 rules, section.
No, the record before us is that he is a, see, as per the
Inquiry form.
we are Nepali, he is a Nepali.
Yes,
Srimati, Srima Manga. What is this? Manga Chetri.
Manmaya Chetri.
Manmaya Chetri.
Yes, Lordship.
Name Srimati Manmaya Chetri. Address Amsing Jorhat.
And
Husband name is Gela Sham.
date of birth 1972.
1972.
Place of birth Kolongpar,
Kolongpa,
Sonapur.
Sonapur.
Yes,
Serial number
Lordship.
together. Serial number part roll together with Assam.
Yes,
And
Lordship.
then he has given number 52 Dispur.
Yes.
Serial number, electoral roll, Assam, mother tongue Nepali,
Nepali.
enquiry officers assessment on dialect spoken Nepali,
Nepali. Yes, Lordship.
and then others are
15.
there. Whether migrated into Assam, no. So what is the inquiry? Inquiry doesn't say that.
I am migrated from specified territory.
My lord, that's why I want to show you,
Very-
2009.
And that plea has been taken in the writ petition.
My lord,
Page 23, Lordship.
2009 rules may be kindly seen, my lord.
2009 rule.
Yes.
Yes.
They are relying on this provision of 21 of 2009 rules.
Section so rule. Which rule you are relying?
2009 rules.
Huh?
Citizenship rule 2009.
Which rule?
My lord, they are referring section rule 21, my lord.
Rule 21.
Jurisdiction of the tribunal. On this ground, they are saying that they are not, their case
No,
cannot be.
We again, Mr. We are not arguing Indra never.
No, I'm not.
What is
arguing, my
the,
lord.
is Indra never a law, settled law now as far as,
As far as my lord citizen, in that case, my lord, there are two categories of citizenship. My lord, two categories of my lord, the foreigners. One is 66 to 71 category, and one is post 71 category. 66 to 71 category, they are to register before the registering authority. This rule is only for that purpose, man. This rule is only for that purpose because, my lord, those
what is Indra never? Let us,
yes, because my lord,
no,
let
what,
me submit that point, my lord. Your lordship will be clear, my lord.
correct.
Because, my lord, why this rule has come? Why, my lord, they have been allowed? 66 to 71 category, those person who has come from East Pakistan, they are allowed to register.
Yes.
Those person who has come from any other countries of the world, except Bangladesh, my lord, except East Pakistan, during this period, they are not allowed to register. My lord.
No,
They are not allowed to
it is
register.
not a
under-
question of allowed or not allowed. They
No,
are not treated to be foreigners.
My lord, they can be declared. In fact, my lord, for Bangladesh, this is by this rule, my lord, only those person who has come from Bangladesh, they have been allowed to stay in India prior up to 71. Those who has come from other parts of the world, they have to show that they are in India prior to 51, my lord. This is only this is my lord, by this, my lord, they have been given some benefit. That's why, my lord, those person, even up their benefit has been extended to 66. Those who has come from 66 to in between 66 to 71, they can register before the, my lord, registering authority, but not except Bangladesh, my lord. No one from East, if he comes from, my lord, Nepal, if he come from Bhutan, if he come from, my lord, Pakistan also, he will be not allowed to register under this provision, 2009 rule. That's why this rule was provided, and rule say if you want to register in between 66 to 71, you have to show that you have to go to the tribunal to prove that you are from, my lord, East Pakistan. That is the rule here, my lord. The normal rule is that whoever is foreigner, my lord, here his reference can be drawn against him, and he may be sent. He can be sent to the foreigners too. But in that case, except from East Pakistan, my lord, they have to prove that they are in India or they are in the state of Assam prior to 51. This is a benefit given to the people who has come from East Pakistan.
But he is not claiming. He say I am coming from Nepali origin.
Then,
I am
my
not from
you
Bangladesh.
just benefit of 66 to
Are
71.
you are you seeking the benefit then?
No.
I'm not seeking, I'm not from the specified territory.
That's why, my lord, if he is not coming from the specific,
I'm by birth, inquiry
cannot
report
say
itself
this.
says that I'm by
Rule
birth.
21 will be applicable for him.
Rule 21.
Yes, Rule 21 of 2009. This is applicable. That is what he says. This will be not applicable for him.
No,
If
this rule 21 will not be applicable.
Yes. This will be applicable only for those person who has come from East Pakistan.
But she's not saying that she is applicable. Why is
That's
she saying
why,
that she is applicable?
then, my lord,
She's not arguing. She's not arguing. She's that I am a Nepali.
only on
Because
this
Indra
ground,
never.
only on this ground, my lord, she's her pleading is that, my lord, she has not come from East Pakistan, so she may not be prosecuted. This is the case, and by this
I don't know about Indra never.
only by this.
But what does the
provision,
Indra never say? Judgment.
Page 112, Lord.
What does Indra never say? Let us go by that judgment. Page
Page 112, relevant portion.
112.
I have annexed the Indira University.
This third para.
Yes,
Huh?
Lordship.
It will be opposite to make a reference. Huh?
Yes, Lordship.
Misconception noticed by Sena about a citizens where a comment with certain class of person commonly Gorkhas were settled in India, and such comment was clarified. Clarification made from the comments of constitution. Every Gorkha who is domiciled in territory of India, who was born in territory of India, or either whose parents are born or who have been ordinarily been resident in India for not less than 5 years, shall be a citizen of India under. So therefore, they are citizens of India. That's a finding. There is yet another notification, ministry, perhaps a guideline making future reference in respect to so-and-so. On the subject, when submitted all so-and-so, items and so-and-so have taken with approval of component while reiterating the conditions of so-and-so, so-and-so, as well as so-and-so. originally he hailed from Nepal, it may not be appropriate to declare all them as specialists. For all reasons, we have no reason but to allow all the 29 plaintiffs by setting aside impugned opinion as well as 39%. A corollary reference against each of them by respective also interfered with. So the court had side aside because they are Nepali
Yes,
on the ground that. So she also saying she's a Nepali,
yes.
not a Bangladeshi Nepali. If you come from Bangladesh,
No.
Nepali, but in, there may be Nepali also in Bangladesh.
I'm from Gorkha community and I'm born and brought up. Even my inquiry report says that. I'm born in Kolongpar, Sonapur.
She's not from Bangladesh.
I'm by birth an Indian.
Inquiry report is not gospel truth, my lord. If it is.
But it is
accepted-
your inquiry report.
Yes,
No, no, my lord,
Lordship.
if it
It's
is
not my
accepted-
If it is not
inquiry.
gospel truth, what is truth? You should have found out.
No, no,
Yes,
my lord,
Lord.
it has to be.
See, Mr. Payang, you cannot take the plea that the inquiry report is not gospel truth. Therefore, only this proceeding will tell what is the gospel truth. Sorry,
No, my
you
lord,
can't do that. It is your case that she is a Bangladeshi or a foreigner, whatever it is. That's what the
my
inquiry
lord,
all
what
for.
my submission is.
And if
that,
you
my-
don't make the inquiry properly, then it's vitiated.
My lord.
You inquire again, fresh
my
inquiry
lord,
again. We
it
can
is- it-
ask them to make
my
a
lord,
fresh
if-
inquiry.
If your lordship will find, my lord, see, my lord. in the
Find
top-
out the gospel truth.
In the top of the form, my lord, it is specifically written on the basis of a statement given by the proceeding.
Correct.
My lord,
For you
proceeding
to,
may give anywhere, my lord. She may say that I was born in Kolongpar. I have to write, I have no option but to write that, my lord.
but then if otherwise, then how do you find out that he's a foreigner? How do you
Anyway,
suspect
my
that
lord,
he's a foreigner?
Once it says that-
That too should-
Once he says.
Anyway, let us not argue on, on this, the already decided case, we are bound by Indra Navar. If, as per Indra Navar, if he is a Gorkha community, then the proceeding will not lie. That is what we understand.
My lord,
If
that
you
has-
differ from it, you have every right to challenge it before the appropriate forum.
my lord, then, my lord, your lordship may remand back. Let them say in the tribunal.
What is to be remanded?
No,
These
my lord,
cases
it
were
is-
not
it is
remanded
because it is an expertise, my lord. It's an expertise. First of all, it is an expertise, my lord. It's not a contested case. If she says that, yes, she is not from East Pakistan, that is the plea that she is not from East Pakistan. my lord. That
Inquiry report says that.
Inquiry report is here before us.
Yes,
What is the
Lordship.
point of remanding?
Yes, Lordship.
What is the point? You
Inquiry
can see
report-
for yourself. This is your inquiry report.
Yes, Lordship.
only on the basis of inquiry report, my lord.
Because on the basis of inquiry report, the proceeding was initiated.
Yes. Only because of the.
It is your inquiry report,
Yes,
not her inquiry report.
Yes, Lordship.
It is, my lord, a statement given by them, my lord.
Whatever it is your, you have agreed whatever. If you have said, you said that, no, we don't agree. And the language also Nepali,
No.
as per the assessment of the inquiry officer. The inquiry officer assessment also given. His own, you cannot go against your own inquiry. There is nothing in the inquiry which would indicate that she is from Bangladesh.
My lord, what is the assessment, my lord? The first of all, my lord, your lordship will find for to reference competent authorities.
So Payang, the more you go deeper, more will also go deeper. And what is the basis of the assessment? Every conclusion must be based on evidence. If there is no evidence, that conclusion is vitiated. We will strike it down at that stage. You go deeper, we'll go deeper also. What is that assessment? What is the, if you say, yes, he's a foreigner, what is the basis for it? There must be evidence. If there is no evidence, then the assessment goes.
My lord, this is.
You go deeper, we'll also go deeper, no problem.
No,
We'll examine deeper.
That your lordship may.
See, what is the basis for that? On that,
Basis-
he has been
basis,
declared
my
a
lord,
foreigner,
is-
suspected to be a foreigner. Please tell us.
Basis-
The record is before you. We'll reproduce an entire record. The scanned copy of it is in our judgment. What is the basis for the authority to come to a conclusion that he is a foreigner?
My lord.
There
my-
must be a basis. That's what the Mondol also says. It cannot be a perfunctory. Muslim Mondol, please take out judgment. What is that inquiry? Is it a fair inquiry? I don't think so. We don't think so. Please tell us that evidence which shows that she's a foreigner. On what basis they have proceeded?
My lord, what happened?
Please,
this is
please, no, please. No,
that's
let
why
us
I'm-
go by the record.
Yes,
We don't
next-
know what actually happens. We don't know. We have no idea what happens outside.
my
We have
lord,
no
this is-
idea.
This is in
You may have a better idea, but we'll go by the records.
This is in the ERO report, my lord.
ERO report, on what basis the ERO says?
Yes, my lord. May I read the?
And it is contrary to the, on what basis what is the ERO? ERO did the do the investigation? Who did the investigation?
My lord, my lord.
We have BRO? Who is the ERO entitled to do the investigation as per law? Tell us. On what basis the ERO comes to a conclusion? He relied on the VRO report. VRO report doesn't say anything.
No, my lord.
ERO report. On what basis the ERO says?
My lord, ERO gives that report on the basis of electoral roll of 1997, my lord. When
We
they-
don't know. We don't know.
No, no,
We
that
don't
is-
know.
that
Yeah,
is
that is you go. We have no idea.
That is indicated
I
here,
will-
my lord. That is indicated here in the.
It does
ERO.
not. It does not necessarily mean that is a foreign. On what basis ERO? Then what was it VLO? Then why do you have
My lord,
undertaken this
my lord,
VLO?
May I submit the procedure, my lord? What is the procedure of? my lord?
We will go
No,
by
no,
the record.
First of all,
We
my lord,
don't know
the
what
record
procedure
reveals-
is followed. We have no idea.
Record would reveal the same, my lord.
The record doesn't reveal anything.
But your lordship will find record in, my lord, this is in the ERO's report.
We have,
May I
we
read-
have anyway you show on the
Yes,
basis of the record you tell us.
I'll read out the report, my
Yes,
lord,
yes.
what is there in there. My lord, whereas Election Commission of India has ordered intensive revision of electoral rule for the 52 Dispur Assembly Constitution Assam with reference to 1197 as the qualifying date. That was the basis, my lord. Whereas house to house enumeration was done during the period from 16 January 1997 to 15 April 1997. Whereas the name Srimati, this is Manmaya Setri, wife of so-and-so, who has declared to be an Indian citizen and has also an ordinary resident of Amsing Jurabat, has been enumerated for inclusion in the draft electoral roll. Whereas the electoral rule of the said constitution published draft on 24/7/1997, including herein the name of the said Srimati Manmaya Setri, and whereas the electoral officer for the assembly constitution doubt about the citizenship of the said person, got the matter verified by an on the spot local verification, and whereas on consideration of the report of
Where is
such
the report?
verification, I have
This is
read
an
the
Where is the
report.
report?
That
Please
is
show us
not
the
a
report.
citizen.
Where is the report? Where is the report?
Report, my lord.
What is the
Next page is, next report is there, my lord.
In the report, what does it say?
That as directed, my lord, I have made necessary verification in respect of Srimati. This is verification officer's report.
In the
my lord.
report, is it mentioned that she is a foreigner?
My lord, may I read the entire report, my lord?
Yes,
Name is Sen
Yes.
Mamsing Setri.
Yes.
Address is Amsing Jurabat. And father's name has been written as Gulsing Setri. Date of birth 72, place of birth Kolagora,
Kolongpar,
Sonapar,
Sonapur.
Kolagpar, Sonapur, Kolongpar, probably.
Kolongpar,
So
Sonapur.
the resident other, and then if serial number part of the electoral rule together constitutes number name. This is my lord, Assam 52 Dispur constituency, her name is appearing
Yes.
on 1997.
97 is appearing?
Yes, 97, my lord.
Appearing anyway. There's a
Suddenly
record.
appearing. That's why my lord did review.
Anyway, then what happened?
Whether mother is registered as electoral rule, yes. If so, serial number of the together with constituency name, part number, serial number is not there, my lord. On this stand 52 dispute. Mother tongue Nepali, inquiry officer assessment of dialect spoken Nepali.
The inquiry officer's assessment is Nepali also.
Yes.
Not Bengali,
Dialect-
not
dialect is
Bengali.
Nepali, my lord.
Ah.
Documentary evidence produced, my lord, no documentary evidence was produced. No documents has been produced.
Then what is the opinion, final, any opinion given?
There is no opinion.
And then?
But they might not be.
If you don't give any opinion, there is no opinion. How can you
Then
say that
whether-
if you don't give any opinion, how will you say that he's a foreigner?
It's no.
There must be a specific opinion that he's a foreigner.
No, my lord.
Otherwise, how do you make an inquiry?
No, my lord, the issue. My lord, the law is that, my lord, when there, my lord, in 1997, intensive revision was done. If her name appears suddenly, my lord, then this report was sent.
Mr.
No,
Mr. Payeng, we are not going to anything else
no,
except
that's
the
why, my
report.
lord. Then, my lord, they sent the matter to the, and my lord, ERO sent.
But then, yes, there must be a finding. They
No, no.
record a suspicion that he is
My
the
lord, the
suspected to be a
ERO
foreigner. Why is that?
ERO suspected has to
How
be
do you
reported.
suspect, on what basis? You just
Basis
read
is
out
my
that EROs is based on the report and you have seen the
My
report.
lord,
In
that
the
is-
report,
that-
does it
that is
mention
not-
anything?
That is not the law, my lord. Law is that, my lord, the ERO suspect is on the basis of 1997 voter list. If his name or her name is appearing suddenly in 97 voter list, that is the suspect, my lord. That's why after extensive revision on the direction of the Election Commission of India, this were done. Then verification officer was asked to verify whether his name can be continued in the voter list. If the verification officer can satisfy, yes, this name can be continued in the electoral voter list, then his name will be continued in the voter list. my lord.
But we don't understand how you make this submission because in Muslim Mandal, nothing is such is
My lord,
referred.
Muslim Mandal has not discussed anything about the ERO's report, my lord. ERO cases. This is purely on the basis of police cases, my lord. Muslim Mandal has never touched the cases of, my lord, those which is coming from ERO, my lord. My lord, this honorable court and has in numbers of cases has that issue has been settled, my lord.
Okay,
That is the issue, my lord.
okay.
Or
Yes,
the
then
basis is, my lord, 1997 voter list. If his name is suddenly appearing in the 1997 voter list, my lord, then the ERO doubts. ERO asks the verification officer, get verified whether his name can be continued in the voter list. If the, my lord, verification officer cannot provide anything, then, my lord, he has no option but to continue, my lord, that send him to the foreigners tribunal. It is the law, my lord. And that is the procedure.
anything else? That's it.
Yes. So if she claims, my lord, let her go and prove that.
Anything else you want? Anything else, Mr. Pai?
No, my lord.
Okay. Nico. Or Miss Learned Counsel for the petitioner, or also Learned Counsel for the Sabka naam likho. The present petition has been filed seeking review of the order
221, page 52, Lord.
page 52.
Yes, Lord.
Page 52. Order dated 2/2/2021, passed in WPC number 6325 of 2019, by which the learned, by which this court declined to interfere with the opinion of the tribunal, which was decided ex parte against the petitioner. Before we go to the rival contentions of the parties, it may be apposite to recollect the basic facts leading to the filing of this review petition. From the records which have been also requisitioned, it appears that a proceeding was initiated against the present petitioner on the basis of certain reference made by the Superintendent of Police Border, Guwahati City, deed in Guwahati City, on the basis of certain inquiry made by the local verification officer and also a verification officer. Consequently, notice was issued, summon was issued to the present petitioner. But did you receive the summon?
Yes, Lordship.
Consequently, notice was issued on being on reference being made to the Foreigners Tribunal, Kamrup Metro, Guwahati. A proceeding was initiated against the petitioner under FT Kamrup Metro DV case number 197 of 2011. It is a case of the petitioner that though the petitioner received, why couldn't you go? Why didn't you appear?
She appeared, she sought several dates, Lordship.
Okay. Petitioner that after receiving the notice from the tribunal, the petitioner appeared for a tribunal, but sought for time in order to collect documents, relevant documents to submit her, to make her in support of her claim. However, according to petitioner, the tribunal proceeded with the matter ex parte against her, resulting in the passing of the ex parte order on
On 12/1/2012, Lordship.
2012. To appreciate the, in order to appreciate the matter better, the impugn ex parte order passed by learned Foreigners Tribunal on 12/1/2012 is reproduced here in below, page 49. Stop. Being aggrieved, what are the plea taken by you in the petition? In that being aggrieved in the
Yes,
petition,
Yes.
being aggrieved, the petitioner preferred a petition challenging the said ex parte order by filing a writ petition being 6325 of 2019.
Yes, Lordship. Page 22, Lordship. She has given the reason why she could not appear before the learned tribunal, Lordship.
In the said writ petition, while reiterating that
Had to
her parents and forefathers from both paternal and maternal side were citizens of India and permanent residents of Borbila, Sonapur of Didian district, Kamrup Metro. And after receipt of notice from the tribunal, she appeared before a tribunal on 31/5/2011, filed an application with a prayer to allow the petition, allow her to file written statement. And accordingly, the matter was fixed on 21/6/2011 by the tribunal, on which date the petitioner also took time to file written statement documents, which was allowed by the tribunal, and the matter was fixed on 29/7/2011. However, thereafter, the petitioner could not appear before a tribunal, as the petitioner had to move from place to place along with her family for their business purposes. And consequently, the matter was proceeded ex parte against the petitioner, resulting in the passing of the judgment order dated 12/1/2012.
Page 23, also paragraph 7, Lordship, he has mentioned that.
Full stop. However, the said petition was dismissed by this court. By this court, what is the order?
Order is at page 52, Lordship.
Page 52.
Yes.
Was dismissed by this court. Primarily on the ground that though the petitioner was given 7 dates by the tribunal for filing the written statement, the petitioner did not appear. And as such, having given, and the court considered that, this court considered that having been given sufficient opportunity to file a statement, if the petitioner does not appear, it was the petitioner can be only blamed for the situation she has put herself to. And since the onus is on the proceeding to discharge her burden to prove that she is an Indian and not a foreigner, and if she does not take necessary steps, the action of the tribunal cannot be faulted with. Learned tribunal, this court also observed that it does not appear that the principle of necessity has been violated, inasmuch as necessary and sufficient opportunity had been given to the petitioner, and accordingly declined to interfere with the ex parte order. Next paragraph. Being agreed with the aforesaid dismissal of the petition, the present review petition has been filed. Full stop. In approaching this court under review jurisdiction, the petitioner has taken an additional plea before this court by stating that after the said review, that in the meantime, this court in Indira Newar and others, Indira Newar versus India and a batch of writ petitions reported in, this is Indian Newar is reported.
Yes, Lordship, but I
Reporting-
don't have this, but I have annexed the judgment.
Correct, but then we have to cite all these numbers, no?
I'll provide.
Reported in, just see, GLT, whatever it is there,
I'll
GLT or
provide that.
GLT or SCC,
GLT, Lordship.
GLT so and so. This court had the occasion to deal with cases of Nepali, cases of
Paragraph, Lordship, page
Relevant?
112.
112.
Yes, Lordship.
They deal with citizenship issues relating to Gurkha community of Nepali origin. In a said batch of writ petitions which were filed by persons belonging to Gurkha community of Nepali origin, this court, after considering the various aspects of the matter, took the view that a proceeding against a person belonging to Gurkha community of Nepali origin will not lie before a foreigner's tribunal, and accordingly set aside all the proceedings pending before the or passed by the foreigners tribunal. First off, it is the case of the specific case of the petitioner that apart from the merit of the case as regards the ex parte, it is a fact that the petitioner belongs to Gurkha community of Nepali origin, which is also clearly reflected in the inquiry held before the proceeding was initiated against her. And as such, her case is also clearly covered by the aforesaid decision in Indira Newar's. If that is so, the proceeding, even if the ex parte against the petitioner would not lie and would liable to be set aside on that ground. However, Mr. Pine, learned counsel for the state, has contested this review petition on the following grounds. Firstly, it has been stated that the petitioner never took this plea. That as regards the plea that the petitioner is a person belonging to Gorkha community of Nepali origin, and as such, no proceeding would lie before a foreigners tribunal. And even though the said decision of this court was rendered as far back in 2020, the petitioner did not take this plea either before the tribunal or before this court when WPC number. When is that WPC number?
WPC number
Your-
6, mine one is 6325.
Yeah, when the-
6325, 2009.
When you filed the writ petition WPC 6325 of 2019. And as such, the petitioner cannot be allowed to raise this plea for the first time in a review petition, which was neither raised before the tribunal nor before the court, while challenging the opinion of the tribunal in WPC number 6325 of 2019.
Inquiry, I have challenged. in
And
the
as such,
resolution.
the plea that you are a Nepali, and as such, this plea will be hit by constructive res judicata. To stop. To stop. Next further. Next further. It has been also submitted that even if that while principle of natural justice also will be applicable in the proceeding before tribunal and before this court also, while dealing with in considering the plea, in considering challenges of the opinion of the learned tribunal, it cannot be extended, it cannot be stretched too far and cannot be said to be applicable in all cases where the petitioner, where the proceeding is responsible for the laches and delay. In this regard, Mr. Payam also has relied on the decision of this court in Indira, in so, what is that earlier,
16-1 GLT.
in 2016, 1 GLT 273, wherein this court observed as follows, quote that, full stop. And according, it has been submitted that this is not a fit case where this court should intervene in a review jurisdiction to interfere with the order passed by the learned tribunal as well as by this court, which does not suffer from any of the infirmities. We have heard the learned counsel for the parties and also perused the materials on record. As mentioned above, it is evident that the ex parte order was passed against the petitioner on the failure of the petitioner to file the written statement. We also have noted that, as observed by this court in WPC number 6325 of 2019, several opportunities were granted to the petitioner to file her written statement, but which she did not, for reasons given by her. Full stop. Normally, such an order passed by the learned tribunal cannot be said to be illegal or vitiated, for the reason that if the proceeding does not take care and promptly file the written statement, the action of the tribunal to proceed ex parte cannot be said to be illegal. However, the situation is, situation is slightly different in the present case, in as much as if we take into account the decision of this court in Indraneva Supra, wherein it has been held that persons belonging to Gorkha community of Nepali origin cannot be proceeded in a foreigners tribunal, and if the present petitioner is indeed a person belonging to that community, certainly certainly, certainly, this court can examine for the reason that if a person who is not otherwise cannot be proceeded by the foreigners tribunal is proceeded, that would lead to serious injustice in spite of laches and laches on the part of such proceeding. Inasmuch as the opinion of a tribunal would ultimately decide the fate of a proceeding. Any opinion to the effect by the tribunal that the proceeding is a foreigner would literally, which is normally to be accepted by the executive, would literally divest such a person of her citizenship. But accordingly, we deem it appropriate to examine the matter in this review petition. Full stop. We have examined, we have gone through the original records, which led to the reference being made against the petitioner. While going through the record, specifically the verification officer's report, which was prepared by one Prakash Bora, assistant geologist, Directorate of Geology, as the local verification officer. The name of the petitioner is clearly mentioned as Srimati Manmaya Chetri, whose address has been given as Amsing Jorhat. Amsing Jorabad.
Jorabad.
Amsing Jorabad, within bracket, School Bosti. And husband's name has been recorded as Sri Ganashyam Chetri.
Yes, sir.
The date of birth is shown as 1972. And the place of birth is shown as Kolongpar, within bracket, Sonapur. As to whether her name is registered as an elector of any constitution of India, it is ticked as no. However, whether his father is registered as elector of any constitution in India, it has been ticked as yes. Yes. In the state of Assam, under 52 Dispur Legislative Assembly constituency. Similarly, the name of the mother also has been shown to be registered as in the 52 Dispur Legislative Assembly constituency. Her mother tongue has been shown as Nepali. And as per the inquiry officer's assessment on the dialect spoken, it is also recorded as Nepali. As regards other columns, these have not been left unfilled, blank. However, as to the column, whether migrated into Assam, it has been ticked as no. There is no further any remark or observation by the inquiry officer, local verification officer. However, while going through the form of reference, form filled up by the concerned ERO, in the form, in the said format prepared by the ERO, it has been mentioned while forwarding, the ERO forwarded the matter to the SP border, as a doubt had arisen as to the citizenship of the petitioner, as no documents was produced. 6. And the SP border referred the matter to the tribunal on the ground that ERO had, it was suspected by the ERO that she is an illegal immigrant. Yes, SIB following. In the format of the prepared by the ERO, there is an remark that SI within bracket B of Nunmati police station was requested to submit a report based on Annexure A and Annexure B. Annexure A refers to the format for Annexure A refers to the verification officer's report, and B is the format prepared for the ERO. When we peruse the record, however, the SIB of Nunmati police station made the following report, which is extracted as below. 7 AM 1/82 type koribo. PS opening of CD note. Open the diary at PS. The case is endorsed to me for completion of inquiry from numbers 8. Form number 7 filled, Roman 7 filled up based on Annexure A and B submitted by Sri Ashok Kumar Burman, ERO 52, Dispur Assembly Constituency, where he suspected Ms. Srimati Monmohi Chetri, wife of Sri Ghanasham Chetri of Amsing, Jorabar, PS Nunmati District, Kamrup, as illegal immigrant. The next entry is made on 7:05 AM, closing the case diary and note. Now I close the case diary at PS and forwarded to the SB Chitri Guwahati for necessary action. There is nothing in the case diary of any statement recorded of anybody, including the proceeding or any of the neighbors, which was required to be undertaken as also requested by the ERO. What we notice is that the case diary was open on the same day and closed on the same day without making any investigation.
Well, probably that is by the SP.
No,
Yes.
no, we see, we'll go by the record. There is
No, no,
nothing in the
as-
record,
as-
whatever.
The report.
You see for yourself.
Yes.
As regards the requirement of
Next,
having proper inquiry.
next city report, my lord.
Yes, it's by the.
Because my lord, once the ERO makes, my lord, the ERO asks for a review for making.
You
report.
see for yourself. As regards the requirement of having fair investigation in matters relating to proceeding in matters relating to foreigners, proceeding, investigation relating to proceeding, investigate fair as regards matter relating to investigation. Before a person is proceeded under the Foreigners Tribunal, this issue has been highlighted by the full bench of this court in State of Assam versus Muslim Mondol 2013, Volume 1, GLT 809. In para 96 of the decision, this court highlighted, the full bench of this court highlighted the importance of fair investigation. Para 96, 97, 98. The full bench of this court highlighted the importance of fair investigation. And it has been also mentioned that the investigating officer, as far as practicable, the investigating officer has to record the statement of the person concerned in presence of village elder or village headman or any respectable person in the locality. The investigation officer also, as far as practicable, obtain the signature or thumb impression of the person against whom such investigation is initiated. While such investigation need not be a detailed one, as in the case of criminal case, yet there must be proper recording of the evidences. This court further went on to observe that the reference by the referral authority also cannot be mechanical, and the referral authority has to apply his mind on the materials collected by the investigating officer during the investigation and make the reference on being satisfied that there are grounds for making such a reference. Para 96, 97, 98 of the aforesaid edition according are reproduced here and below. What we have noted is that, as mentioned above, from the record which is available before us, there was practically no investigation carried out by the SI border, which was required to be done at the request as requested by the ERO. At the same time, in the report submitted by the local verification officer, there is nothing to indicate that the petitioner is a foreigner. Be it as it may, in our view, we may not go much detail into this aspect for the reason that we are satisfied that as far as the report is concerned, she appears to be a person of Gorkha community of Nepali origin. If that aspect has been clearly mentioned, reflected in the inquiry report. If that is so, her case would be covered by the decision rendered by this court in Indra Newar versus so-and-so reported so-and-so. Since we are satisfied based on the original record which is produced before us, that the petitioner is indeed a person belonging to Gorkha community of Nepali origin, we may not go further into the matter, as we feel that it will be sufficient to hold that no proceeding could have been initiated before a tribunal. Though we have noted the submission advanced by Mr. Payeng that this plea was not taken, yet in our view, since this has been brought to our notice at this stage, and which goes to the very root of the matter, in as much as a person who is otherwise not a foreigner and judicially taken note, as mentioned above in Indira case, if we allow the proceeding to proceed or uphold the opinion of the tribunal or the judgment of this court rendered in 6/25/2019, it would lead to serious prejudice in as much as the citizenship of the petitioner will be divested because of the ex parte order, which we feel can be can be rectified even at this stage.
Only one point, my lord, I have
Yes,
not
yes,
been married,
yes.
my lord, your lordship, as your lordship has, my lord, recorded. My lord, this is directed to ST border, SI borders to ensure. So please submit report on the basis of annexure A and B.
And he must, because he has to verify, no?
My lord, verify only annexure A and B. That means A and B.
But
is
what the
there.
verification he has done, he has not
No,
done
my
anything.
lord, what system? May I submit the system? Otherwise, it will go, my lord, negative way, my lord. My lord, the once.
No, we are not making any observation. That is
as
why
your lordship has
we are
recorded-
not, see, that is why we have
My lord,
keep it open. Mr. Payeng, though we have made some observation, we are not setting aside on that ground. We are setting aside on the ground of Indira Nevar.
I'm
That is
on
why.
that, my lord. I have
That is why we are keeping it open.
My
You
lord,
can argue in some other case.
Your
Yes.
lordship, my lord, for as your lordship knows it, my lord. Your lordship knows it, my lord. Once the ERO send the reference to the SP for reference, the police has no authority to make further.
We don't know what is, we are
No,
going by the
no,
record.
no,
Your
that is- my lord,
ERO again is asking the SP
my lord,
border.
ERO has that because, my lord, without report of the my lord, SI border, it will not submit it.
Then what is
That's
the
why
SI?
he was directed to submit report on the basis of this annexure A and B, my lord.
Correct.
On the basis of this annexure A and B. He read this annexure A and B and submitted the report. He cannot go for further inquiry. That is the law, my lord. That's why as your lordship has
Okay,
said, he has not
Mr. Payeng, as regards the aforesaid procedure adopted, Mr. Payeng submits that the SI border who are directed to submit the report was merely to look into the Form A and the Form B, Annexure A and Annexure B.
annexure A and B. my lord.
And he was not required to undertake any further inquiry into that. We make no further comment on this in as much as we have allowed the petition on the basis of the Indira Nevar case. Accordingly, for the reason discussed above, the petition is review petition is allowed by recalling the order passed by this court in WPC number
6325/2019.
and having considered the materials on record, we interfere with the we set aside the impugned ex parte order dated
12/1/2012.
12 now 12
12/1/2012.
passed by the FT in so and so. With the petition stands, accordingly review petition stands allowed. Yes. I'll check this. Okay. তার আগত লিখিব হা though normally when the review petition allowed by recalling the order passed by this court challenging the opinion of the tribunal, the matter could have been remanded to the tribunal for fresh reconsideration, but in the present case we have the view that remanding the matter would serve no purpose in as much as we are satisfied based on the original record as mentioned that the petitioner it belongs to Nepali say Gorkha community of Nepali origin who is stated to be a resident of this country. Under the circumstance, we have the view that no purpose, no useful purpose will be served by remanding the matter to the tribunal, and accordingly we have opted to dispose of this matter at our own at this stage at our own at our instance by setting aside the impugned order passed by the land FT.
Deeply organized lordship.
Item number 2.
But in these cases, my lord, there are numbers of cases, my lord. In
Okay.
your lordship may kindly see the earlier order, my lord. The issue of delay and laches was there, my lord. And there was some argument. Your lordship has fixed some other matters on
Okay.
24.
Okay, 24.
So let this matter come after 24, my lord. Let
Okay,
it
this after 24, yes, on the premise.
Probably all these matters, my lord. It is
Whatever, yes, all this matters.
Yes.
2 to 4. 2 to 4.
Review matters. So
Review matters.
2 to 7, my lord.
After, 2 to 7.
Yes, my lord. The delay
Okay.
issue was there, my lord.
Okay,
That's why it was.
okay. no.
Let it come after 24, my lord, then.
After 24, then December kori diyo.
6/12.
24, your lordship is hearing the.
Okay, okay. Then this will come up in December. Huh?
Yes.
No interim, my lord, interim protection will be granted, my lord.
Where in
My lord,
interim protection where in
my
W-
lord. Item 2, my lord,
item 2.
my lord.
Okay, this second on the prayer of Mr. Payeng, the matter stand adjourned to 6/12. In the meantime, if the review petitioner has not been detained on the strength of the impugn order dated, page number,
My lord, page number. My lord, at page 107, tribunal order,
So,
31/5/2019.
he may not be detained and reported, and he may be allowed to remain on bail, however, subject to furnishing a bail bond of his 5,000 sitting, biometrics, everything, a mobile phone.
My lord.
A mobile phone. Do you have
My-
mobile phone? Inform
My
the
lord, I
police.
don't know, well, may have.
When you buy a mobile phone, if you don't have. Otherwise, this will be a additional security. Security. These are also a physical form of bond. One is paper bond. This is physical form bond. Because then, otherwise, how the police will keep a track? They will find out and where you are going. And they can also Payeng can track from the mobile tower whether you are going to Bangladesh or not. It will be easily detected if you use the mobile phone. There is a reason why we are giving mobile phone. It can be detected wherever you go. It will also be recorded.
My lord.
Yes, item number 3. Yes, this will come up on 6/12. You are already on interim.
Oh, my lord, we're not in interim.
Give your same. Then yes, Chaudhary, item number 4. You also on
I'm
interim.
already on interim,
Very
lordship.
good then. So
Lordship, can
6.
it be on 7/12?
Okay, 7/12. Okay, on the prayer of Miss. Then Mohela Khatun.
Yes, my lord.
Mohela Khatun also 7/12. You are already in interim.
Yes.
Then Ghosh, Padma Devi. Padma Devi is a Nepali or what?
Yes, both next 6, 7, both are Nepali.
Nepali, then what to do? Because that's what to do. Nepali to Nepali, what to do? See, you can't.
Records are here.
Mr. Payeng, without Nepali also in this country will be in danger. They have defended this
And even-
country for the, all the battles.
Yeah.
We are always
Jagat
indebted.
Chetri was in
We are
defense.
indebted to these Gorkhas, Nepalis, for protecting this country also.
Hindu Nepal.
Jagat Chetri was in
provided-
Gorkha.
Not Hindu Nepal treaty has provided them every opportunity,
Correct, correct.
every right,
Yes.
except citizenship.
Correct. So, but at least they cannot be deported.
Yes,
No?
that is the issue. my lord.
So we'll see the Indira Nevar. Are you covered by Indira Nevar?
Yes, both the
Yes,
cases.
What the cases, then we'll allow this. What to do,
And
Mr.
Jagat Chetri was in defense. He served Gorkha rifles.
See, Mr.
And I have annexed those documents.
See, they have fought the. So
That's
we'll
why,
dispose it off then.
Yes.
Oh, that Padma Devi. Review. We'll only, we will not go to this Mr. Payeng verification report, so we'll just rely on Nevar.
Yes,
We'll go on Nevar.
on the basis of.
Never, huh?
Let the-
Okay. Okay. What is the impugn order by the tribunal?
Yes, impugn order is at page.
Tribunal.
Tribunal 13/2/2012
Page
impugn order.
number.
Page number, Lordship. Is at page number 40, Lordship. 40.
Contestant issue. Yes, yes. Huh? Yes, tribunal, please,
Page 40, Lordship.
40.
Yes, Lordship. Three references taken together. I'm in serial number 2.
Bhagavati and others, you are not concerned.
No, not concerned.
Okay, very well. Now, this order was passed ex parte also.
Yes, Lordship.
Why didn't you appear?
The reason is that with my husband, because petition, review petitioner number in petition 7, they're husband and wife. Item number 7.
Jagat Chetri
Jagat Chetri.
is the husband.
Yes.
So you'll go where the husband takes you.
Yes, Lordship.
Buying what to do? Indian women, Nepali women, they'll go wherever the husband takes. And husband go and the wife also follows. There's also a reality in this subcontinent. They are
Yes.
not independent. They'll go wherever the husband goes.
All are not independent.
Not independent. And they are not independent lawyers or something like they can practice and so then what is the opinion of this judgment of this court which you seek review?
Page number 51, Lordship.
Page 51.
Yes, Lordship. 1/2/2021.
51.
Yes, Lordship.
What is this? What is the court say? The same thing that
Same
you are
thing.
given
Yes.
support, huh?
Yes, Lordship.
And then same. Okay. Likho. And Ms. Ghoslani Council House to Moksa Spencer. In this petition, and the present review petition has been filed seeking review of the order passed by this court. Review of the order dated 1/2/2021 passed by this court in WPC number 6416 of 2019. By which the challenge made by the petitioner to the ex parte order passed by the learned FT or dated 13/2/2012 passed by the Foreigners Tribunal Kamrup M Guwahati in FT Kamrup MV DV case number 198/2011 declaring her to be a foreigner of post 77 has been dismissed on the ground primarily on the ground that though the petitioner was afforded opportunity to file her written statement on as many as 1, 2, 4 occasions, the petitioner remained absent without taking step, and as such, the petitioner has to be blamed for the situation she finds herself. And it was also observed that it cannot be said that the principles of natural justice was violated in the present case, in as much as the petitioner failed to, in as much as all the necessary procedures were taken in accordance with law, and as such, and accordingly dismissed the said writ petition WPC number 6416 of 2019. Full stop. Next paragraph. Ms. Ghosh, however, submits that though it is not a case that the petitioner was totally negligent of the proceeding, in as much as the petitioner appeared before the tribunal for filing her written statement, but because of this fact that what is the reason you have given?
Yeah, because after his service, he went for business purpose to several places. Page 22,
the
Lordship.
petitioner being a wife of Jagat Bahadur, who was traveling from place to place in search of livelihood, she had to follow her husband, resulting in failure to appear before the tribunal and file a written statement. And it is not of gross negligence, but due to reasons which was beyond her control. Full stop. Otherwise, also it happens, Ms. Ghosh submits that in the meantime, this court had passed an order in Indira Newas versus Swansu in the report in Swansu, wherein it has been held by this court. Mr. Dotto, that also you reduce that in Indira Newas. That para number. In that case, internal page numbers, you reproduce the finding of this court in Indira Newas. Internal page number. Internal page, or what is that in the present, the finding of this court?
110, Lordship.
110,
Yes, Lordship.
In this case, 110.
Yes, Lordship. 110, 11.
110,
Yes, Lordship.
then 110. internal page 50. Yes, internal page 50. No.
51.
No. No. Page. Page no 49. Internal page 49. We have undertaken a rigorous exercise too. No. Then page 50, 49, 50, 51. 51. Huh? Yes, it will reproduce corridor. And submitted in so I held that persons of Gorkha community of Nepali origin cannot be proceeded under the foreigners tribunals, and such proceedings do not lie. And in that case, this court set aside all the opinions rendered by the foreigners tribunal QUA persons of Nepali Gorkha community of Nepali origin. And it has been submitted that in the present case, the records would reveal that the present petitioner is a person of Gorkha community, belonging to Gorkha community with Nepali origin. And according it has been submitted that that the present petition may be allowed by recalling the order of this court passed in WPC number so and so, and by setting aside the ex parte order passed by the learned foreigners tribunal in so and so. Mr. Payne, however, submits that there is nothing wrong with the order passed by the foreigners tribunal or for that matter by this court, inasmuch as if the petitioner failed to appear for the tribunal in spite of giving several opportunities, she has to blame herself. Further, the opinion, the order of this court, setting aside the challenge, dismissing the petition also cannot be said to suffer from any infirmity, as this court also had clearly observed that the petitioner was afforded several opportunities, but she failed to appear, and that this court also did not detect any violation of the principle of natural justice. And as such, it has been submitted by Mr. Payne that the present review petition is not cannot be set is without any merit and liable to be set aside. Though we appreciate the submission advanced by Mr. Payne that the petitioner was afforded several opportunities to appear and file her written statement, and also we do not find any infirmity as such, legal infirmity as such, in the order sought to be reviewed. What has struck us is that there is a decision of this court passed in Indranavar Supra, wherein it has been held by this court held by this court that persons of Nepali origin, Gorkha community of Nepali origin cannot be proceeded in a foreigners tribunal. And in the said case of Indranavar, this court after being satisfied that the petitioners therein are all belonging to Nepali Gorkha community of Nepali origin, set aside all the proceedings. The relevant portions of the offers of judgment in Nevar are reproduced here in below. Accordingly, we have also examined ourselves from the original record as to whether the present petitioner is a person of Nepali of a Nepali origin. While going through the original record, specifically, more particularly the verification officer's report, which is available before us, it is clearly mentioned that the petitioner Srimati Padma Devi, is a resident of Amsing, Jorabad school within bracket school Bosti. Padma Devi, was born in the year 1957 in Moran, which is in Assam. It has been also mentioned that she has been registered as an elector of the constituency in 52 district constituency, though eliminated in 1993. Similarly, her father's name also registered as an electorate in the Moran Assembly constituency in Assam. So is the mother of the petitioner, who has been shown to be registered as an elector of Moran Assembly Legislative Assembly constituency in Assam. and her mother tongue has been shown to be Nepali. The inquiry officer's assessment on the dialect spoken also has been recorded as Nepali. In the column, the remaining column being not filled up, in the column 15, where as to whether she had migrated into Assam, it has been ticked as no. There is no observation by the local vetting officer that she is suspected to be foreigner. Full stop. Though reference was made on the basis of the opinion of the ERO that she is suspected of foreigner, what is plainly evident is that she is a person of Nepali community of Nepali origin, though she claims to be a resident of this country. Full stop. Under the circumstances, in view of the decision rendered by this court in Indre Navar versus so-and-so Supra, we have the view that the petitioner has been able to establish that she is a person of Nepali origin, in which event proceeding before the tribunal would not lie. Full stop. Therefore, we have the view that even if the petitioner was guilty of leches, in as much as not in appearing before a tribunal to file the written statement as observed by the learned tribunal, as also by this court, the fact that in view of the fact that she is a person of Gorkha community of Nepali origin, the proceeding obviously could not have, the petitioner could not have been obviously proceeded. Even if proceeded, in view of the decision of the this court in Indre Navar case, such an proceeding cannot be sustained in law. Full stop. Accordingly, without going into the other merit aspect of the matter, since we are satisfied that she belongs to Nepali community, which has been community, the case will be covered by her case will be covered by Indre Navar, and accordingly, we allow this review petition. Normally, and though while sitting in review jurisdiction, the matter could have been remanded to the tribunal for fresh reconsideration. We have the view that that exercise will be a futile exercise in as much as the original record which are before us clearly indicates that the petitioner belongs to Nepali community. And as such, for the reasons discussed above, we allow this review petition by recalling recalling the order passed by us in WPC number
6416/2019.
and set aside the impugned ex parte order dated so-and-so passed by the FT tribunal so-and-so.
Deeply obliged.
Then next. Same also, same, the husband.
Yes.
Today we have disposed of a petition WPC number review petition number 40 of 2009, in which one Padma Devi was the review petitioner and who was a proceeding in a FT case number so-and-so. It has been submitted by Ms. Ghosh that the present petitioner Jagat Chetri or alias Jagat Bahadur Chetri is the husband of the aforesaid Padma Devi. Is
Yes.
it so?
Yes, Lordship.
Okay. Accordingly, though in the present case also the petitioner was proceeded ex parte by which order? Page
48, Lordship.
Page 48.
Yeah, 10/1/2012, Lordship.
Page 48. Was proceeded ex parte by order 10/1/2012 on the ground that the petitioner did not appear before a tribunal to file her written statement in spite of giving opportunities. And the challenge to which also has been dismissed by this court in WPC number page
58, Lordship. 6428/2019.
page 58.
58, Lordship.
Also dismissed by this court in WPC number 6428 of 2019
Yeah.
on the ground that though the petitioner was given sufficient opportunity to appear before tribunal, the petitioner failed to file a written statement, and as such, and since there was no violation of the principle of natural justice, the challenge to the ex parte order passed by the learned tribunal was rejected. Full stop. It is against this. This is the present review petition has been filed seeking review of the order dated 1/2/2021 in WPC number 6428. It is the plea of the. It is also the similar plea of the petitioner that the petitioner being a person of Nepali origin, in view of the decision rendered by by this court in Indira Nevas versus so and so GLT, so and so reported so and so 2021 GLT
2021 GLT
21 GLT
413.
413. The proceeding before the foreigners tribunal would not lie, and if that is so, the order passed by this court dismissing the writ petition in WPC number 6/2018 may be also recalled. In order to Mr. Pai submitted that one. However, considering the submission advanced by Ms. Ghosh that the petitioner is a person of Nepali origin, we have examined the record ourselves, which has been requisitioned before us. On perusal of the record, specifically the finding the report of the verification officer, what we have noticed also is that the petitioner Jagat,
Yes, Jagat Chetri.
Jagat, what is that? The petitioner, the proceeding petitioner Jagat Bahadur Chetri, son of late Bhojman Chetri, is a resident of Jagat Bahadur Chetri, resident of Amsing Jorabad, School Bosti, son of late Bhojman Chetri, was born in 1937 in Dibrugarh, and he's shown to have, his name is shown to be registered as an elector of 52 Dispur, as a legislative assembly constituted in Part G 10, though shown to be eliminated in 1993. As regards the mother, she has been also shown to be registered as an elector of Dibrugarh Legislative Assembly constituency. He also has been shown to he also has been shown as a Nepali. The mother tongue of the procedure has been shown as Nepali, and the inquiry officer's assessment on the dialect spoken is recorded as Nepali. The report also shows that he holds a land in 1990. In column number 14, Roman 4, it is mentioned that citizenship certificate has been issued by the office of the Deputy Commissioner Kamrup on 28/2/1986.
Yes.
And as to whether he migrated in Assam, it has been indicated as no. There is no other observation that he is a person of foreign origin. Though reference was made against him in the verification officer report, from the verification officer, it is clearly evident that his mother tongue is Nepali, and also was inquiry officer assessment also that he speaks Nepali, and accordingly, we are satisfied that the petitioner is a person of Nepali origin, in which event his case also covered by a decision of this Indira Nevar.
Your lordship may mention that he is a Nepali who has not come from specified territory.
Okay. There is nothing also in the report which indicates that he has come from a specified territory. Under the circumstances, that this sentence you write in the all others also. Yes, sir. Under the circumstances, we are satisfied that the case of the petitioner will be squarely covered by the decision of this court in Indira Nevar so and so. Under the circumstances, we allow this petition by recalling the order dated passed by this court in so and so, and resultantly, and though we might have remanded a matter to tribunal, we are with you that considering the records which have been produced, original records which are available before us, it will be a futile exercise to remand the matter to the tribunal. Accordingly, we have proceeded to examine the matter ourselves and having satisfied that the petitioner he is found to be a Nepali origin and as there is no such finding by any of the authorities that he has come from specified territory, his case will be covered by the decision decision in Indian hours, and accordingly the impugn ex parte order so and so is set aside. Petitions allowed. That's it.
That's it.
So we go. Huh? Anything?
No, my lord.
Then why it is coming?
Fourth time, my lord.
Huh?
Fourth time, my lord.
Fourth time.
Yes,
So will admit, the records have been received, so we'll admit.
Yes, my lord.
Notice have been issued.
No, my lord.
Issue notice, records have been received, the matter can be heard. That's all?
My lord.
What do you want? We'll hear it.
Yes, my lord. My lord. My lord. My lord, during the trial, my lord, the petitioner has exhibited certain documents in respect of her father, my lord. Her father, my lord, casted vote in the year 1965 and my lord 1971, my lord. May I, my lord?
So we'll hear. No problem. Since the records have been received,
Yes.
the matter will be listed for hearing. You have been in detention or no?
No, my lord, outside,
Outside?
my lord.
You want to go to detention center?
No, my lord.
No,
My
no.
interim period may be allowed, my lord.
But you have not asked for it. How should I?
No, I think my lord, lordship heard today itself, my lord.
Huh?
I think my lord, lordship want to heard this matter today itself, my lord. That's
Finally,
my,
final order.
my lord, I think so, my lord.
What do you think? By there's still 2022 matter, there are so many matters. Huh? Okay. In the interim, the petitioner had not been detailed on the stand of the impure notice mentions. Next. Matter will be listed for hearing since the records have been received. Huh? Yes.
2,
My lord, LCR has been received
Okay.
and there is an interim order also.
Interim order, very good. Okay. Since the records have been received, the matter will be listed for hearing.
Obliged.
3,
Mr. Lordship, the LCR has been received
Hmm.
in this case. Your Lordship, in page number 20, annexure A, the opinion of the tribunal was here.
So what is wrong with the opinion?
In this opinion, in page number 20, the foreigners tribunal, may I please read the order, read the opinion. Considering the entire material on record, exhibited documents and evidence produced by the proceeding and the discussions above, the tribunal opined that the opposite party, Jahura Khatun, wife of Sensor Village Florence Sonitpur, Assam has miserably failed to discharge her burden to prove under Section 9 of Foreigners Act 1946. That
So you fail to prove, then what to do now?
Here, my lord, after cutoff date is 25th March 1971, then my lordship in page number 21, it was the reference of the SP border, Sonitpur. May I please read the order?
Oh, you came 66 to 71.
Yes, yes, 66 to
Ah.
71. And then,
Oh,
your lordship, in a similar matter, in WBC 2434/2020, Gulapi Begum, His Honorable Court has ordered,
pace.
pays, the judgment was annexed.
You want annexed the judgment? Have you annexed? Golapi.
No, yes, your lordship. Judgment,
Golapi Begum.
judgment, judgment. Your lordship, in para 16. Assessment.
In between 1166 to 24/3/1971. Final order also says allegation is that OP had illegally entered into between 1166 to 71. Huh, Mr. Sharma? In a final order also. This is the reference, but the finding is that is not permissible. It has been held in Santosh Das also.
Yes, sir.
2017 to GLT.
Yes, sir.
Huh?
Cannot go beyond reference. Lord.
So we'll remand it,
Yes, sir.
or
If-
we'll declare her to be foreigner of that period if you want.
If reference is.
No, no, can you be remanded the matter?
Remanding. Remanding.
Beyond cut of death. Sir, she entered India after cut of death.
So the finding is that it is she came after 25/3/1971. This is contrary. GLT 2017 volume 2 GLT 1065. You got a copy of the
My lord. For the time being, can I go to?
record. In the reference also it is mentioned. In that VRO, no, just see. Take out the printout. You want to admit that she came between that, he came between, or you want to contest that? Which one you want? If you want to contest, we'll remand. If you say yes, I'm a foreigner between that, we'll close it. We'll direct to her. Huh?
No, she's not a foreigner.
She's not a foreigner.
She's not a foreigner.
Okay.
Lordship may kindly take note of the written statement submitted by the Procedural Lordship. Paragraph 3 at page 32 and paragraph 11 at page 37.
What does that say in the written statement?
She says, I am reading Lordship,
Yes.
that the opposite party begs to state that the
Page
delegate-
number here.
Page number 32, Annexure C,
Page number 32, yes.
paragraph
Ah.
3. That the opposite party begs to state that the allegations made against the opposite party in paragraph 1 to the notice are totally incorrect, false and baseless, and hence denied by the opposite party. And prosecution is put to the strictest proof thereof. The
Yes.
opposite party further denies that she has infiltrated in Assam and has been residing illegally, and thereby reiterates that she is a bona fide Indian citizen. The same thing reflects in page 37 at paragraph 11. This is additional written statement filed by the opposite.
But she said that
Brown and Bota, paragraph 4.
he said that she was born and brought up in India and her father's name is registered in 1965.
I am submitting in context whether context of the stream Lordship. If as per reference, she has entered between 66 and 71.
Yeah.
And the finding of the opinion is that she has entered if the-
After 71.
Yes, Lordship. And in both the cases, irrelevant of to the stream, the petitioner denies all the allegations, Lordship. If we go according to the reference and go beyond the reference, I am submitting in that context.
Will remand.
Yes.
Digo, Han means
SZ Hayat.
S
SZ Hayat.
Z Z
Z.
S Z Hayat.
Yes.
And a counsel for the petitioner. Also, Mr.
And Pathak.
N.
Pathak.
Pathak, no? Counsel for the standing counsel for the state. As well as सबका नाम लिखो, हाँ, सबका सबका In this petition, the petitioner has challenged by this petition. In this petition, the petitioner challenged the opinion. What is their opinion? Page
Page 20, 17,
FT.
page 17, my lordship,
Page.
page 17, 17.
The petitioner has challenged the opinion dated 25/11/2021 passed by the learned Foreigners Tribunal, Tezpur 5th at Bishwanath Chariali, Bishwanath, Assam, in BNC/FT, in case number BNC/FT, page 17, so, by which the petitioner was declared to be a foreigner who had entered India within Assam after a cut-off date of 25/3/1971. Learned counsel for the petitioner submits that apart from other grounds taken to challenge the validity of the finding of the learned tribunal, it has been submitted that the finding of the tribunal itself cannot be sustained in law on the ground is inasmuch as though the petitioner was suspected to be an illegal immigrant who had entered India between 1/1/1966 to 24/3/1971, as mentioned in the reference. The tribunal gave a finding that she had entered India, Assam, after 25/3/19, which is not permissible, as held by this court in a number of cases. And on that ground only, the matter, the impugn order of the tribunal is required to be set aside, and the matter be remanded for fresh reconciliation. In view of the above submission made, we have examined the matter. We have confined our examination only to that aspect only. And aspect. Perusal of the impugn order would also clearly show that in the first paragraph itself, the learned tribunal had recorded that reference was received from the competent authority, Superintendent of Police within bracket B, Sonitpur, Tezpur, and the allegation is that the opposite party, Jahra Khatun, had illegally entered into India within bracket Assam in between the period of 1/1/1966 to 24/3/1971 without valid document. However, the learned tribunal, after considering the evidence on record, came to the finding that she had entered India after cut-off date of 25/3/1971 without authority. Para 1 of the opinion of the learned tribunal reads as follows. And finding at para 10 of the learned tribunal is as follows. Thus, it is quite apparent that while the reference was made against the petitioner that she had entered India between the period of 1/1/1966, 24/3/1971, but the finding is that she entered India after 25/3/1971. As regards this aspect, we have also gone through the original record which have been requisitioned. In the original record, on perusal of the report prepared by the SP border, as well as people with the SP border, it is clearly mentioned that the petitioner has been staying in government land with her family, and she had entered and she had been continually staying in India between 1/1/66 to 24/3/1971. And they gave the and as per the report submitted by the SI, Sub-Inspector of Border Police, Behali Police Station, dated 6/3/2007, as mentioned in the said report, it is mentioned that it is mentioned as follows, within quote, page 20, original record. Sir, in a prima facie manner of inquiry, it appears that Musammat Jawhara Khatun is a foreigner of E/P, who entered into India in between 1166 to 24/3/1979 without any valid document. Hence, the case is submitted to the Honorable FT Court T2PR for trial. Full stop. Thus, from the record also, it is clearly evident that that the petitioner has been accused of entering India during the aforesaid period of 11/1996, 24/3/1971. Next one. Thus, under such circumstances, as to what will be the effect of the opinion rendered by a tribunal, to the effect that the proceeding had entered after 24/3/1975, 25/3, in spite of a reference being made that the proceeding had entered between 11/1966 to 24/3/1971, has been already considered by this court in a number of cases. In an earlier decision of this court rendered in WPC number 7551 of 2016, party name of the party, Santosh Das versus India, reported in 2017, volume 2, GLP 1065. This court, on consideration of similar issue, held that if held that the tribunal gets his jurisdiction to render his opinion only when a reference is made to it. And if a reference is made that a person had illegally entered India from the specified territory during the period of 11/1966 to 24/3/1971, the tribunal was required to answer the reference either in favor of the state or in favor of the proceeding. But in the present case, tribunal had given a finding not with reference to the reference made, but on his own, that but gave a finding that the petitioner entered India after 25/3/1971. And accordingly held that the finding of the tribunal in the said case that the proceeding to be foreigner who had illegally entered India from a special after 25/3/1970 could not be sustained in law. This court took a similar view in a subsequent case in Golapi Begum versus so in WPC number 2434/2020. Parallel counsel for the state also fairly admits the legal position that the tribunal could not have given a different opinion, not in consonance with the reference made. And in the present case, it is clear that the reference was as to whether the petitioner had entered India, Assam, between the period of 11/1966 to 24/3/1970, as also clearly mentioned in the in para 1 of the final order. However, the learned tribunal gave the finding that the petitioner entered India after 25/3/1970, which in our view cannot be sustained in law as held by this court on earlier occasions as referred to above. Under the circumstances, we allow this petition without going to the other merit of the grounds taken in the petition. We allow this petition by setting aside the final order dated 25/11/2021, passing FT number so and so, page 17, and remand the matter to the learned FT for fresh reconsideration and to render his opinion in terms of the reference made against the petitioner to the effect that she had entered India during the period of 1/1/1966 to 24/3/1971. According to the presently allowed, the petitioner will appear before the FT within a period of 1 month from today. And the learned FT, the foreigner tribunal, after hearing the petition again on the basis of the evidence so adduced, will pass a fresh opinion. Yes. Let the LCR be remitted forthwith to the concerned FT. Next,
For admission, item number 4.
August, Your Lordship.
Oberon BB, what is this?
Yes, my lord.
Oberon.
This is governed by adjudication judgment of apex court matter of the Kudus matter. First time he was declared foreigner. Second time when notice was served, he filed a
Tribunal lordship. Let the matter be remanded back.
Why remand back, my lord? I have been declared Indian.
Tribunal lordship.
Again harassment.
No harassment lordship.
Yes. The other day when your lordship wanted to dispose it, my learned friend Bharma took this time that they should hear the matter. Today she is not here.
They have to this before the tribunal lordship.
My lord, I take your lordship into judgment first, my lord.
Just a minute, let us see what is the judgment you relied upon? What is the judgment? That you are declared Indian.
Yes, sir.
What is the judgment? You filed-
Page 14, my lord.
No, in the before the tribunal you also filed, no?
Yes. I have been declared Indian. First, my lord, that is on 6/5/2016.
You filed a copy of that before the learned
Yes,
tribunal?
yes, that is the page 17. With all, with the reference of the apex court also. But it was rejected and asked me to file written statement.
You have been asked to file written statement.
Yes,
Now, any opinion been rendered now? Noted.
yes, I have not appeared again.
Huh?
I have not appeared subsequently case.
Then it was declared, you are declared Indian, foreigner.
Foreign, my lord. Page 39.
But you should appear and explain.
I have given explanation. Apex quoted the judgment of apex court and the annexed the judgment. Earlier
But you
judgment.
say, why didn't you appear? You
I-
say you do not appear, why?
My lord, page 17, can you see?
Why? You should have appeared.
Well, this is the order passed by the learned tribunal, kind of. Page 20, page 17, my lord. We have appeared. And page 19 is the order passed by the learned tribunal below. 15321.
Proceeding for closing down the present reference.
Hmm. Let us see that earlier opinion.
Yes, earlier opinion is my lord.
Page,
Page 14.
page
14.
1.
That is the judgment, my lord. Dated
Reference again opinion, D voter case, reference for registered, reference for a pion, I peruse, OPS suspected. Oberon BB,
Yes, yes.
you are Oberon BB?
Yes, yes.
Muhammad Oberon BB, daughter of Saber Ali.
Yes. Wife of
Daughter of
Joiner.
Saber Ali, wife of
Joiner.
Joinal Abidin. Village Sotibar,
Exactly.
PS
Dhaligaon.
Dhaligaon. The same, there is no difference then.
Yes, Lord.
Voter list 1970, village number Pataka.
Yes.
Let us see your exhibit 3 is the voter list of, in the earlier case, 1971. Let us
Yes.
see that 1971 voter list. Have you annexed this 1979 voter list?
I am not annexed here, my lord.
No, in the, do you file it in the, before a tribunal? Voter list of 1979 pertaining to village number 7, Gaon number, Patha,
Yes,
Patakara,
in that case, my lord,
Pratham 39, Jaleshwar, LAC
we have
constituency.
submitted in that case.
He records the name of Saber Ali. Saber Ali, son of Astulya, 24 years, wife of Moiful Nesha. His wife Moiful Nesha, besides another is voter number 23, Mohiran Bhai. Brother, the same thing. No? Then there is a point. The same thing. Same.
Page
It is a
20
voter
last
is
paragraph.
1979. Is a father of OP reference. Then 1990s.
After filing this application, remain only on that ground, there's no proof. WS is nothing. In that way, this is whether it is part by as indicated, that issue is not.
Lane gone recently, huh?
There is a copy.
I'm hearing, but taking
It is pertinent to mention it fast.
hearing on the said petition could not be taken up.
Because of the COVID.
Then you take it up then.
Then they will take it up, that application. That
Mm. And in the para,
Which paragraph?
what is that order passed on that day?
Our opinion page 15.
No, not that one. In that page 20, what is that reference
Yeah,
with me?
last paragraph. Page 20 last paragraph.
Page 20, last
Last
para.
para.
Hence, what a length. It was without present, the question of the person is not illegal. No. The learned assistant has submitted, although one answer negative, never on the basis of conversation, namely, may not be closed since there is no provision for. 15.3 on 15.3/2021.
Yes.
Reference we made. Is Abdul Kudus closing the line.
Yeah, that also
learned-
we discussed, my lord.
Somewhere has reference, the
Yes.
learned assistant.
But even they're not accepted.
No, on 15.3/2021, you are present on that day.
Yes. That was the order passed on that day, rejecting my prayer. And not to continue the second proceedings.
Then no, then we are see 15.3/2021.
Yes, my lord.
Then what is the final opinion?
Final opinion is, my lord, at
5:10.
yes, 5:10. For 2021 order is important.
Hmm.
9/4/2021. On 9/4, that application was rejected as per this order.
Maybe here. So just please have a look. 811,
Mine four was fixed for Douglas.
811, 8.
15 is the order.
And Mr. Nico, Mr. Lane, and Mr. Lane counsel for the petitioner, also Lane counsel for the state. We will dictate after the second half. We will dictate after the same. At 2 p.m. 2 p.m. 2 p.m. will 2 p.m. will while dictating we'll skip for lunch and we'll prevent you to have lunch also. If we continue this dictation, you'll be also present here. So neither can we have lunch nor you can have lunch. And when you go out of the courtroom, you will say that, oh, because of this judge, I didn't have my lunch. So that we don't want to take any blame. What? Anyway, this will dictate as will do. Also, Mr. Sharma for the standing counsel for the state. Baki sab likhna, right? Everybody's name, huh? And so, in this petition, petitioner had challenged the opinion dated 5/10/2021 passed by the Learned Foreigners Tribunal, Chirang, Assam, in reference case number FT/CHR/16/2019. See page number 39. Huh? Check all the details. Huh? By which the petitioner was declared to be a foreigner who had entered the state after 25/3/1971. This opinion has been challenged primarily on the ground that the tribunal did not properly consider the issue of res judicata while passing the opinion. In fact, rather ignored the same in spite of being specifically pleaded. Full stop. It is the case of the petitioner that the petitioner was earlier declared to be not a foreigner but an Indian by an opinion. What is the earlier opinion?
Page 14.
Opinion dated 6/5/2016 passed by the, what is that foreigner? For the same tribunal? No. By the Foreigners Tribunal, Chirang, in case number BNGN/FT within bracket CHR 396/2007, wide opinion dated 6/5/2016, whereby Musammad Abiran Bibi, daughter of Saber Ali Sheikh, wife of MD Joinal Abidin, resident of village Sotibar, PS Dhaligaon, was born in Assam accordingly. The reference was answered in the negative against the state. Thus, it was held that the OP, that the said proceedee is a citizen of India by birth, not a foreigner. Full stop. In order to appreciate the aforesaid contention, full stop. In order to appreciate the aforesaid contention, we have gone through the original record which have been requisitioned and also the pleadings. Full stop. from the pleading, it appears, from the record, it appears that the present petitioner had indeed filed an application being application of petition number 66 of oblique 2020.
Yes, yes.
By claiming that the proceeding had been was already declared as an Indian citizen as per the aforesaid case number FT/CHR/396/2007 on 6/5/2016 by the Foreigners Tribunal Chirang. Full stop. On perusal, though we have also noted that though the learned tribunal has mentioned about such a plea being taken in the impugn order, it was the learned tribunal had in the said the petitioner had specifically the proceeding had taken a specific plea as also recorded in the impugn order that the present proceeding is hit by res judicata in view of the law laid down by the Honorable Supreme Court in Abdul Quddus versus Union of India, 2005,
Yes. I'm sorry, not 2005, 2020 minute. Page number 2005 SC 2920.
However, learned tribunal observed that 2009 Abdul Quddus, 2019 volume 6 SCC 604. However, learned tribunal observed that
Because of this order. So
However,
this order is also on the certificate of
Okay.
presentation.
okay, the learned tribunal referred to its earlier order passed on 15/3/2021, in which the application filed by the proceeding for closing the petition on the basis of res judicata, the learned tribunal by order dated 15/3/2021 held that after hearing the parties held that that the proceeding could not be closed as there is no such provision for
Yes.
closure of proceeding under the Foreigners Act 1946 and the Foreigners Tribunal Order 1964. Inasmuch as the tribunal was required to give his opinion on the reference being made. And without perusing the written statement and evidence on affidavit, the tribunal cannot determine the question as to whether a person is an illegal immigrant or not. Full stop. And accordingly, learned tribunal, after rejecting the aforesaid application filed by the proceeding, vide petition number 66 of 2020, on 15/3/2021, proceeded with the proceeding,
Yes.
directing the petitioner to file her written
WS.
statement.
Yes.
Written statement. It appears from the records that the petitioner did not file her written statement.
Yes.
Why did you file?
Because I thought that I am already declared Indian, but it is the misuse.
File, did not file a written statement and did not file on the, as the petitioner bona fide believed that once she was declared to be an Indian, there was no need to prove and contest the proceeding. Be it as it may, what we have noted from the original records is that the But what is this? Some documents were filed,
Yes, we have filed everything, my lord, yeah.
but you say written statement was not filed, you say again.
In earlier case, you filed.
No, 2016, these are all earlier matter. 2016. Huh? See,
You can do this since their decision was not taken. If you can say the sudden decide application the application 66
hmm,
instead of going to
yes.
because that is also under challenge.
Yes.
Because it will not have 15.
We have also noted that the petitioner also had challenged the said decision rendered by the foreigners tribunal in petition number 66 of 2021, rejecting the plea of res judicata raised by the petitioner. Stop. While we have on perusal of the order dated 15/3/2021 passed by the learned foreigners tribunal, rejecting the plea of res judicata, what we have observed is that the learned tribunal appears to have been persuaded by the submission advanced by the learned assistant government pleader that the foreigners tribunal has to give an opinion in the reference drawn by the referral authority regarding the question whether a particular person is an illegal immigrant or not, which is required to be answered either in affirmative or in a negative after perusal of the materials on record and the written statement and evidence on affidavit submitted by the proceeding, and after appreciating the evidence adduced by the proceeding. Full stop. While we have as regards the aforesaid reasoning given by the tribunal, we have the view that while the proceeding may file her written statement giving all the relevant documents, yet that issue as to whether the proceeding is hit by res judicata has to be considered by the tribunal on the basis of evidence that may be adduced. And if the petitioner has adduced sufficient evidence for that particular for consideration of the issue as to whether a proceeding is hit by res judicata or not, it may not be necessary to adduce all the evidences, but only that will would be necessary and sufficient to prove the case that prove the plea of the proceeding that there has been already an opinion rendered in her favor. In the present case, what we have noted is that the proceeding did file a certified copy. The survey copy, what is that?
Certificate copy was not.
You did not file. Have you filed a copy of that?
No, we have not filed. Earlier case we have filed.
No. In the you have to file. No, that otherwise, why should the tribunal just accept you just because you are saying you have to file?
Judgment copy we filed in earlier case.
Judgment copy. Now,
Yes.
what is that judgment copy? You have to file that judgment copy, whatever. We will see the petition.
In my application data, page 17, I have mentioned about the judgment, my lord. Full.
Merely mention will not do, na.
Where is your petition? I have 66. Have you annexed that?
No, he's outside.
Petition 66 of 2020, on the basis of which you claim that it is hit by res judicata. Where is that application? Have you
Yes.
annexed with the petition?
That is page 17, my lord.
Yes. What are the annexes of?
In page 17,
Para 4, my lord. Can you see, my lord?
full bench was
Para
also.
para 3 also. Challenging again issued another notice, my lord. Then para 2 also I have mentioned that hearing the parties filing this WS before the honorable court by the parties, and thereafter the member have to declare the applicant an Indian citizen. Annexure 1, I have annexed, my lord.
with this in the original language will draw to file. Is the photocopy of the order opinion dated 6/5/16.
We have noted, what we have noted from the application filed by the proceedee is that while making the application, which was numbered as 22,
Number is 66 dated
66 of 22.
Yes.
What we have noted is the petitioner had filed a photocopy of the order oblique opinion dated 6/5/2016 in case number BNGN/FT/Chirang/396/27
As Annexure 1.
as Annexure 1.
Yes.
We have the view that the petitioner ought to file a certified copy of the such a opinion in as much as that would be the basis for his claim for res judicata. And also the proceeding has to show by adducing evidence that she is the same person who was proceeded earlier. To that extent, we have the view that that there is certain lapses on the part of the proceeding. Yet we also have noted that learned tribunal, on the other hand, went on to observe that once a reference has been made, it has no option but to make a answer either in the affirmative or in the negative, full stop. While that is the basic purpose of the tribunal, yet if there is a finding by the tribunal that the case of the petitioner is covered, is hit by res judicata, in as much as the proceeding has been already declared to be Indian, naturally, the natural course would be to answer the reference in the negative against the state and in the positive in favor of the proceeding. But in the impugned order passed by the learned tribunal, the tribunal did not appear to have adopted the aforesaid course of action. Full stop. Accordingly, full stop. We have also examined the records from the copy of the opinion rendered by the tribunal earlier in VGN/FT CHR 396/2007. It is mentioned there is a reference to Exhibit 3, which is a voter list of 1979 pertaining to village number 7, Pataka under number 39, Jaleshwar LAC, in which the name of one Saber Ali, son of Asatullah, 24 years, and his wife Moiful Nessa, beside another person whose voter has been reflected under house number 23. And in the said opinion, it has been mentioned that the said Saber Ali is the father of the said proceeding, namely Musammad Aviram Bibi. Similarly, in the exhibit number 4, which was relied upon by the learned foreigners tribunal in the earlier opinion, it is a copy of the common voter list of 1997 pertaining to village number 4, Bortaula under number 32, Bongagaon LAC. It records, besides others, the name of the father of the OP as voter against serial number 901 under house number 344. Full stop. On the basis of the aforesaid documents, the learned tribunal held that the proceeding, namely Musammad Aviram Bibi, daughter of Saber Ali Sheikh, wife of Muhammad Joinal Abidin, resident of village Sotibar, PS Dholigaon, to be an Indian and not a foreigner. In the present case, what we have also noted that the proceeding who have been proceeded is one Abiran Bibi.
Yes,
Abiran Bibi, daughter of Saber Ali. Saber Ali, daughter of Saber Ali Sheikh, wife of MD Joinal Abidin,
Yes.
resident of village Sotibar, PS Dholigaon, of resident of district Chirang, BTC, Assam.
Yes, ma'am.
And in the records which are available before this court, we also have noted, we also observed that those voter lists. Voter list, that here. In the proceeding, in the records, original record which is available before this court, we also see that certain that the written statement has been filed. This is in the present written have been filed on 11/1/2016, in which certain voter lists also have been annexed, including the voter list of 1979, which also reflects similar entry as mentioned in the earlier opinion of the FT. The other voter lists of 1997, which is also 1997, 66, 70. In 1997, there is also reference of Sober Ali, son of Astullah, in respect of 32 Bongaigaon Vidhan Sabha Legislative Assembly. Same village?
Yes, my father covered.
Similar as exhibit, which is similar to the document which was exhibited exhibit 4 in the earlier opinion. Thus, we are satisfied that as far as the name of the present petitioner and the proceeding earlier appear to be same. However, since this aspect was not considered by the learned tribunal, we have the view that it will be more appropriate if the learned tribunal examines the same. Accordingly, we remand this matter. Accordingly, we have the view that the plea of the petitioner that the present petition, that the petitioner was already declared an Indian in an earlier opinion rendered by the Foreigners Tribunal, Chirang, in case number BNGN/FT CHR 396 on 6/5/2006, requires to be considered by the Foreigners Tribunal again afresh in the light of the evidence which have been already on the basis of the documents and other evidences which have been already placed on record by brought to the notice of a tribunal. Consequently, the tribunal will be required first to examine this issue as to whether the petitioner case is covered by principal res judicata in view of the earlier opinion rendered by the FT in BNGN/FT CHR 396/2007 opinion dated 6/5/2016 in the case number BNGN/FT CHR 396. If the learned tribunal comes to conclusion that the present petitioner is the same person who was proceeded and was declared an Indian, the proceeding will be immediately concluded in favor of the petitioner without any further examination on other issues. According to the prisoner allowed by setting aside the impugn so the petitioner will appear, impugn order dated 5/10/2021, and the petitioner will appear before the and also the order dated 15/3/2021 passed by the learned FT in petition number 66 of 2021.
Yes, ma'am.
The petitioner will appear for the FT and learned tribunal, after hearing the petitioner in the light of observation made above, will pass a fresh opinion. It is only if the learned tribunal comes to a different conclusion that the petitioner that the matter will be heard afresh, will proceed in accordance with law, and that the petitioner will be liberty to challenge any such opinion, including on the issue of res judicata which have been raised by him as mentioned above. The petitioner during the penance of the proceeding, the petitioner will be allowed to remain on bail in terms you were granted bail earlier.
Yes, yes.
In terms of the earlier order passed by this court and 2/2/2022. Let the LCR be remitted forthwith to the concerned
Madam, date
FT.
of appearance, when I will
within 1 month from today.
oblige.
LCR remitted.
Item number 5.
Rohima Khatun, what is this?
Lordship.
Yes, what is this?
Lordship, my lord, there is a case pending before the learned foreign tribunal for Goalpara, my lord. My lord, the evidence has been laid, my lord, and the witnesses were also cross-examined, my lord. In the meantime, my lord, I have find, my lord, one linkage certificate, my lord. After cross-examination of witnesses, my lord, thereafter I filed an application, my lord, that page 61 kindly may be seen.
Yes.
Page 61, my lord, my lord, I filed an application before the tribunal that I may be allowed to exhibit one linkage certificate issued by the Secretary of Goshaidu VCP, my lord, which was missing at the time of submission of WS and evidence in chief, my lord. But that petition was rejected by the tribunal, my lord, on the ground that already the my lord, witnesses are cross-examined, and therefore, my lord, he cannot entertain this petition, my lord. Page 61 is my application, and page 62 is the order, my lord.
What is the certificate?
My
Show the
lord, page
certificate.
60, my lord. Page 60.
This certificate we issued when? 4/7/2015.
15, my lord, at the time of application for NRC, my lord.
And
Yeah.
when did you file the written statement?
The written statement filed, my lord. On 18 September 2018,
Where is it, please?
page 38, my lord. And 42 is the date, my lord. Page 42. My lord, in this regard,
Yes, Mr. Sharma.
I am to rely, my lord, one judgment of Abdul Salam, my lord.
The opinion has not yet been rendered, no?
Right.
Not yet rendered.
Not
Not yet rendered. If it rendered, then another issue, not yet rendered. And Mr.
M. Ali.
Learned Counsel for the petitioner, also Learned Counsel for the state. The present petition has been filed challenging the order dated 21/7/2022 passed by Learned of FT in case number M165 of /18 with reference to the FT case number. What is the FT case number?
My lord, application number FT within bracket G4 M /165/2018.
Where is it? Where do we find?
My lord,
Page 19, there is only case number M160.
Case number
WS.
FTG4 M/165/18
yes, my lord.
pending before the FTG4 at Goalpara, Foreign Tribunal Goalpara, by which the Learned Tribunal had rejected the application of the petitioner to file a document, namely what? What is the document? Namely a
Linkage certificate.
linkage
Linkage
certificate
certificate.
issued by the
Secretary of Goshaidubi Gao Panchayat.
Secretary of the
Goshaidubi Gao Panchayat.
Goshai
Goshaidubi
Gaon Panchayat.
Dated 9/7/2015. 9/7/2015.
9/7 or 4/7?
Regarding this certificate,
4/7, my lord. I'm sorry.
did
4/7/2015.
not take any pleadings, no. before the tribunal, and petitioner proceeding could not go beyond pleading, lordship. No pleading
Evidence
has
is
been
one
taken,
thing, pleading is one thing.
Not necessarily they will have to plead that this activity.
See, in pleading, I am an Indian. There is a pleading. In pleading, you are not supposed to mention all the evidence. This is evidence to prove that he is Indian. Law pleading, as we understand, I don't know, subject to, there may be new development in law, but law pleading, as I understand, in a plain, you are not supposed to mention the evidence. You are just to plead your case. This is my case, so and so, so and so. Then evidence will come. That is what, because by which the link certificate issued by so and so was not allowed. 4.7 was not allowed on the ground that the petitioner did not utter a single word about this document, and also the DW2 had been duly cross-examined and discharged. And as such, and discharged. Similarly, DW3 also had been cross-examined and discharged. And as such, if this is allowed at this stage, it will amount to filling up a lacuna. We have gone through we have perused the records and heard the learned counsel for the parties. Yes, though the procedure was supposed to furnish the document in support of his or her, Rahima, her case that she is Indian, not a foreigner, at a first available opportunity, that will be subject to availability of the records. In the present case, it has been specifically pleaded by the petitioner that the aforesaid document was missing and was not available when she filed the written statement on 18/9/2018. We have also noticed that the said document is dated 4/7/2015, which was issued earlier prior to the filing of written statement. But full stop. And as such, if the petitioner claimed that the said document was missing and could not be filed, the same cannot be totally disbelieved. Secondly, we also, secondly, the observation of the learned tribunal that the same has been filed at this stage after examination of witnesses and to fill up a lacuna perhaps cannot be accepted in full, in as much as in a proceeding before the foreigners tribunal, the state does not need any evidence. It is only the proceeding who has to lead the evidence to prove his or her case that she is Indian, not a foreigner. And as such, the question of filling up any lacuna perhaps may not arise, especially in view of the submission made by the petitioner that that document was missing and could not be traced at the time the filing of the written statement. Full stop. Section 9 of the Foreigners Act 1946 casts a burden on a proceeding to prove that she is not a foreigner but an Indian. And as such, under the circumstances, if the petitioner seeks to rely on certain document which was missing earlier but could be traced out later on, it can be said that the petitioner, that the proceeding is trying to fill up a lacuna. In fact, it would enable her to prove that she is Indian, not a foreigner, and thus help in discharging the burden. Full stop. We have been also informed that the learned tribunal has not yet given any opinion in this regard. If that is so, we have the view that no serious prejudice will be caused to the state if the said document is allowed to be filed and approved in accordance with law. And accordingly, we allow this application by setting aside the impugned order dated 21/7/2020 passed by the AFT in so-and-so case number page 62. The petitioner may be allowed to file the said document and approve the same in accordance with the law, and thereafter the tribunal will render his opinion as regards the reference made. With the above original petition, allow the petition to appear for the FT on or so and so. Huh?
My lord, within 15 days.
The records be written, records be remitted and remitted, and a petition will appear for the tribunal within,
December 16. my lord.
yeah, on or before 16 December.
16 December.
With this one. And the FT will, tribunal, learned tribunal proceed with the matter in accordance with law.
Obliged, lord. Highly obliged.
Item number 6.
Mujahil Ali,
May I please, your lordship? My lord, the petitioner in custody, my lord, and my lord, LCR were called from.
so what to
Lord,
do?
he was arrested on 8/9/2022.
So what to do?
My lord, he may be released from jail.
Why should he be released on bail? You are already declared to be a foreigner.
My lord, apart from this, my lord, the petitioner exhibited 9 documents, my lord,
What?
including the voter list of 1966, where his father's name is appeared. And my lord, his name is appeared along with his father in the voter list of 1997. All those documents were exhibited, but that documents were not trustworthy.
You know, if you don't file trustworthy document, what the tribunal can do?
That is the view of the tribunal, my lord.
So what is wrong with that view?
My lord, the documents are, my lord, correct, my lord. My lord, opinion at page, my lord, 57.
You show us anything wrong with this opinion. What is wrong with the opinion? You have to first satisfy us.
That is only there, my lord. My lord, kindly come to page 64. The para 8. From para 7, my lord. I have analyzed the entire evidence of the said OPDW1 and the documents accompanying therewith, and also peruse the materials available on the record. The statements made in the evidence of the OPDW1 and 2, who is the elder brother, my lord, pertaining to his documents as stated above, have not been affirmed at all the required under the law, and thus having no evidentiary relevance. My lord, para 8, the set of documentary evidence produced by the said OPDW1 would demonstrate are not in conformity in any manner, rendering the same untrustworthy and unreliable. That is only, my lord.
Yes, Mr. Sharma.
Yes. Lordship.
Yes.
Heard of merit, lordship.
But
Regarding bail, lordship.
7, there is no, what is the conclusion, the basis for what is the reason? Tribunal has to give some reason, no, for arriving at a conclusion. We are not able to understand what the learned tribunal is saying. I have analyzed the entire evidence and perused. The statement made in evidence pertaining to I have not been affirmed at all. Means what? We don't know. Was not been affirmed at all in accordance to law. We are not able to understand the observation, conclusion.
Lordship may fix it on any other day, lord. Tomorrow day.
My lord, LCR already received, my lord.
In the meantime, I will.
My lord,
to be LCR.
What is the document? Who is your father?
father's name is, my lord, Moniruddin Ali.
How is you say that your father? Show us any
Father's
document.
name is, my lord, appeared in the voter list of 1966
Page,
at page, my lord, 28. Page 28, my lord. Moniruddin.
page. Moniruddin.
Yes, my lord.
Dulia Gaon.
Guliagaon.
Then
Then, my lord, exhibit, my lord, exhibit 4, page 30, my lord, that is NRC details, my lord. There
NRC
also
details.
His father, my lord.
Father,
Yes, my lord.
Dulia Gaon, village. Dulia
Page
Gaon.
32 also, my lord.
Dulia Gaon.
Yes, my lord.
Then 32 is which NRC?
32 NRC, my lord. And thereafter,
Dulia
my lord,
Gaon,
page
Dulia.
37, my lord, 97 total list.
But village Khonikor Gaon. What is Khonikor Gaon?
Konikorgaon, my lord, adjacent village, my lord.
Adjacent.
That is, my lord,
Their
explained, discussed in the WS as well as, my lord, written evidence also. my lord.
PS
How
their
big?
Gaon. Police station.
Under
Their
the
Gaon.
same police station.
And where are you now?
Now, my lord, he is my lord at Gulaghat,
Moniruddin, Bosti, Dergaon.
Dergaon.
And who is your brother? What is your brother?
His brother, my lord, elder brother, his, my lord, evidence was declined, my lord.
Why?
My lord, kindly see the, my lord, judgment.
No, why is the evidence here?
Evidence is not there, my lord. My
Why?
lord, my lord,
Declined, why?
his evidence was declined by the tribunal.
Why?
That is not mentioned, my lord.
Why? What do you mean by decline?
My lord, but in the, my lord, kindly,
Where you say, how do you say is decline? Where is it? Where is it? Where is it?
his, my lord, his evidence is, my lord, written evidence. His cross is, my lord.
Cross also there.
DW1 cross is not there, my lord.
Why it was
Yes.
declined? Tell us the reason. He didn't turn up again. He ran away.
That is not mentioned in the judgment.
Are you should know why he was declined.
That is not mentioned in the judgment.
The judgment doesn't
But-
matter. You should know why it was declined.
My lord, para 7, kindly see, my lord. Here the evidence of OP/DW1 and DW2. But DW, he was, my lord, not cross-examined.
Why it was not cross-examined?
That is not mentioned in the.
Oh, it is not matter. You must be knowing why it was not cross-examined. He didn't come or what? During the cross-examination.
He has come, my lord, but he was not cross-examined.
Yes, is one. There must be some reason.
And my lord, there are concurrently two proceedings.
Just a minute, just a minute. DW1, what is the name?
His name is my
Brother,
lord.
brother.
Elder brother, my lord. His name is not also there.
You don't come prepared. You are preparing the case in the courtroom next week. Chalo. Come prepared. Don't come to the court preparing the court. You're wasting our time. So next.
Stay matters, item number 9,
Next is my lord, date may be fixed. my lord.
2212.
Yes, next. Yes.
Obliging.
Item number 9, stay matters.
What is stay matter? What do you mean by stay matter?
My lord, my order.
What stay? You have to stay. You have got a stay order.
No, my lord, I don't know what for. My lord, your lost me, please to see order dated 3/12/2018.
You have a very good order. She shall be detained and deported. Yes, record received the matter will serve for hearing. Next,
Item 10,
item number 10. What is this item number 10? Records have been received, the matter will serve for hearing.
Interim is there, but interim.
Interim mother will continue. Yes, very good. Next,
item number 11,
Noor Hussain.
It's also same.
Huh?
Also same.
Okay, since records have been received, matter will serve for hearing.
12,
12. Kutu Nam Sudro.
Same.
Huh?
Same.
Since the records have been received, matter will for hearing.
Interim order, my lord.
Early interim order will continue.
13,
Kad Banu.
But it may be disposed of, my lord, because
Huh?
my lord, this matter may be disposed of, my lord.
Why?
My lord, this is void ab initio, my lord.
Why?
Proceeding. My lord, there is absolutely no inquiry, my lord. Page 29, my lord.
No inquiry.
No inquiry.
No inquiry was held.
Inquiry was held, but nothing to show that the petitioner is doubtful, my lord. Page 29, kindly visit.
We will see the original record.
LBO's report, my lord.
LVS report.
LBO.
Yes.
Supreme Police. For verification officer. Kad Bhanu. Date of birth 1960. We register no. Golpara. Assamese.
My lord,
Kad Bhanu Nesa. She could not produce link certificate. Her citizenship is doubtful. Assamese.
column number 8, 9, my lord. Whether father is registered as an elector of any constituency? Yes.
No, it was.
If so, serial number, part number, something, my lord. Voter list of 1966 Perus. Then, my lord, para 12, mother
The
tongue.
father is, yes. The father is mentioned in Golpara, 1966.
1966. Golpara West LS. Then, my lord, next, whether migrated into Assam, yes, no, nothing. my lord.
Mother tongue also Assamese. Enquiry officers assessment of dialect spoken Assamese. Then what to do?
Lordship, I need time, Lordship.
How long?
Lordship,
How long you need? How long you need?
Lordship, next week. Lordship.
Next week, okay. On the prayer of Mrs. Sharma, better listen on. Yes.
2911.
Obliged.
For hearing
Yes.
item number 7.
What hearing? What hearing? Sigdar.
May I please, Lordship?
What hearing? Just give me one sentence. Why?
My lord, in this case, my lord, what happened, my lord, inquiry was made, my lord. By
Huh?
the inquiry was made against me, my lord,
Ah.
and after inquiry, my lord, a reference was made that, my lord, I am not a foreigner, my lord, I am an Indian citizen.
Oh, is it so?
Yes, my lord. Kindly, my lord, try to pace, my lord.
Just a minute, just a minute, just a minute. Goirun Bibi.
Yes, my lord.
Lordship will
In the
kindly
inquiry,
see
it is
the-
an Indian.
Yes, my lord.
How do you say so?
My lord, kindly try to pace, my lord.
Lordship, may peruse last order, Lordship, you are directed to produce some instructions, but I need further 1 week time, Lordship.
What 1 week? Just a minute.
My lord,
Durban Bibi.
Page
There is not
26, ma'am.
require village.
Lordship, order.
No
dated
require. She's staying now husband. Village.
relevant portion. from-
Simlabari, not required, but not required. She produced copy of the voter list. 19 is father name, right? Not required. During my inquiry in the prime facility is found that suspected is not foreigner. She is Indian origin.
Time to, my
Oh,
lord,
oh, oh, oh.
26, my lord, relevant portion, my lord, page 26.
She
my lord,
stated the
conclusion,
husband.
Conclusion, my lord,
During
page
my
26.
inquiry information is found that suspected is not foreigner. Sorry.
Hence, the case may be perfect.
Brother.
Okay, L to football.
Your inquiry says she is not a foreigner, then how did you proceed against her, mister?
No, Mock said like that, Lordship.
What is it like that? This is here record. See. What is the another inquiry?
No, Lordship.
What inquiry? See, the original is before, we don't know what is the record. This is the original record is before us. It says, even
During my inquiry information, when it is found that the is not a foreigner, she is an Indian citizen.
if there is a finding by the inquiry report, then how can you proceed, Mr. Sharma? What is this? What? This is an inquiry report, your own inquiry report. Not her. Who is that? This Goiron Bibi.
Because it is written by somebody else, referred by somebody else. That's why it two different.
For what if foreigner traveler do be intimation that the suspect does not appear to be foreigner? Does not appear to be foreigner. Both. They refer to the foreigner traveler that it does not appear to be foreigner. Then what is you refer only when she is suspected to be a foreigner. Otherwise not. Otherwise, if they also refer Justice Koteshwar to foreigner, then they will have a problem. You can say that yes, he is suspected to be a foreigner. So he should be removed from judgeship. That is another okay. But if you say not suspected to be foreigner, how can you refer to foreigner tribunal?
Perhaps be dropped.
Dropped also, Is there?
Yes, my lord.
Oh.
Page 27.
Likho, har Mr. See, we go by the record. Har Mr.
Yes, yes, Shikdar, my lord.
Lane Council for the petitioners. What is this? This also Mr. Also Lane Swanshaw. So in this petition has challenged the opinion dated 11/11/2015 passed by Lane FT in 6 Jubri so. Dekhna. By which the petitioner has been declared to be a foreigner of who came to Assam after 25/3/1971. So stop. Next para. Petitioner has assailed his opinion primarily on the ground that in the inquiry which was held before that reference was made, there was a clear-cut finding by the authorities, inquiring authority, as well as by the referral authority that the petitioner is not a foreigner but an Indian. Nevertheless, for reasons which we fail to understand also, the matter was referred to the Foreigners Tribunal and the said opinion was rendered. We have also perused the opinion, we have perused the original report which is produced before us. In the report prepared by the OC, in the report, the inquiry officer, it has been clearly mentioned that that during the inquiry, in a prima facie manner, it is found that the suspected Muhammad Gurian Bibi is not a foreigner. She is an Indian citizen. Based on the aforesaid inquiry report, the Superintendent of Police also made an observation forwarded to the Foreigners Tribunal Dhubri with the intimation that the suspect does not appear to be a foreigner, hence the case may be perhaps dropped. We also have gone through the other portions, other form 2, which have been prepared by the OC of the police station Bilasipara, where it has been, where nothing is mentioned as to whether she is in foreigner or Indian, but mentions that the proceedee had stayed with her husband at village Simala Bari, yes, Bilasipara.
My lord, map is, my lord,
Yes, yes.
my lord.
In the report prepared by the SI Nipendra Sharma, it has been also clearly mentioned that during my inquiry within court, during my inquiry in prima facie manner, it is found that the suspected Gorian Bibi is not foreigner. She is an Indian citizen. Stop.
My lord,
Yes, what do you want?
my lord. SP is not confident regarding her citizenship status. That's why it was forwarded to Foreigners Tribunal. Lord.
No, anyway,
For better exam, to examine.
anyway, then. We fail to understand under what circumstances the proceedee who was found not to be a foreigner but to be an Indian citizen by the concerned verification officer as well as the referral officer would have been referred to the Foreigners Tribunal. A Foreigners Tribunal can only decide cases where a person is suspected to be foreigner. It cannot certainly decide a matter in which there is a clear finding and observation that a person is not a foreigner. Under the circumstances, we have no other alternative but to set aside the impugned so and so in the light of the original records which have been produced before us. Impugned. Next,
Item number 8.
Shukurjan Ali. Non appears. Yes. Now we shift from foreigners to criminals, Indian criminals. We have had enough of foreigners today. Now we deal with the normal Indian criminals who have been convicted.
Additional hearing list, item numbers 1 to 4.
Yes, sir. So Moinul Haq is the one who has been
Capital punishment.
capital punishment. What is the evidence against him?
Yes, my lord.
His case comes under the rarest of the rarest. Bachchan Singh or something? Huh? Yes, Mr.
Statement of accomplice and
Anand Bhuya, I mean, death sentence,
Rarest of the.
rarest of the rarest. Does it come under that category, rarest of the rarest?
From the evidence on record, my lord, to be precise, my lord, absolutely.
Is there?
No, my lord,
It is not there.
but it is a case of life sentence.
Very, very hard.
Yes.
It's a heinous crime,
Yeah,
but
heinous.
nevertheless not a rarest of the rarest.
Yes.
So let us first confine to that, perhaps then we'll proceed with the other appeal. Others have been, what about this Salimuddin? Is the same case or what?
He has been sued.
Same, they're different accused, huh?
Yeah.
They're the same case.
Same case.
And Salimuddin has been life,
Life.
okay. And what about Bimal Bora also?
My lord.
They have filed a petition for enhancement appeal.
Bimal Bora wants
For enhancements, my lord.
enhancement to from LI to
From life to death, my lord. And that's been the part of my lord here in this case, my lord. After the client approached me, my lord. After going to the evidence on record, second opinion, then I have to mention this. Then Neeladatta sir, I sent it, my client to him. Then it's been part of this that he advises in that manner. So that was been preferred.
no problem. There is no issue. We
Yes.
can always hear it because obviously persons who have suffered,
Yes,
they
they have a right. my
they have a
lord.
right, you know.
Only
they
on the
may
ground
feel-
of parity, one is been given death and another is life. Why not of the same occurrence? So.
all should be given death.
That's it.
Death sentence.
That's
Reverse parity or one other.
Okay, because since the dead reference, obviously first priority will be there. So let us see, examine dispassionately without being swayed by emotion, because crime, especially those and the victim side, we always feel.
Absolutely.
You know, we have seen that.
No
we've seen
doubt of it. That's why it has been introduced the victimology.
that.
That's why
Yes,
CRPC was amended, my lord.
yes, we remember just last month only in America also,
My-
that young man, he killed about 10, 15 the students.
Yes, absolutely.
And the trial went on, and of course, many people were expecting death sentence of that young man.
Yeah.
But then jury decided perhaps that no. So it was not given. So the family members, some of the family members were not at all happy. They are all perceptions, of course, because depending on the heinousness of the crime committed. So it will be a natural reaction to avoid capital punishment. But then we have to go by law.
Absolutely.
What does the law say?
My lord,
Because
Supreme
rare-
Court time and again is saying that to convict a person is quite easier,
Is
but to sentence a person is the difficult part on the part of the judges.
Yes, and especially when it comes to death sentence.
Yeah, absolutely. Because your lordship now will see there is a new development in the Supreme Court yesterday only, my lord. That one Swaminanda, which case we'll be referring it, my lord, he was granted death sentence. So it was converted into life. Then he prayed that life means 14 years. Then the Honorable Supreme Court come up with the proposition, no. If the date is converted to life, it means for the whole life.
Whole life.
No,
Till-
without remission, right, man?
Correct.
So now he is claiming parity with the release of the prisoners of Rajiv Gandhi murder case, man. Nalini and all, my lord.
Hmm.
He said that they killed 17 people and I kill only one. Why should I be kept for the life, for the whole of the life? Why not I also be released after 31 years he is incarnated, madam. And they have been incarnated for 27 years. So that's why the Supreme Court is now in a perplexed
Correct.
situation.
They are all very difficult, as you mentioned also.
So
They are-
notice was issued on the,
Correct.
that's
They are,
accused petition.
yes, because sentencing, it becomes, yes, but then, yes, there will be always a difference of views
Right.
as to the quantum, but the capital punishment is the maximum.
Maximum.
Therefore, whether a person deserves to be given that maximum punishment, whether it falls within the parameters of our Supreme Court
Guideline principle.
guidelines, perhaps we have to examine first
Absolutely.
on that. So then we'll first deal with the death sentence, obviously, of this Moinul Haq case.
Right.
So let us see what is the evidence against him.
My lord. Well, while taking up, my lord, I think we can hear both the appeal together because factually all the aspects are the same, my lord.
Yes. So once
Only
actually-
the sentencing part of life and death will
Yes.
come after the case is established.
correct,
my lord.
yes, that is true.
So let us go with the evidence. my
Yes,
lord,
correct.
both
That
the-
is what that we want to see the evidence
Yes.
because that will be the basis for
Yeah.
any our
Taking any decision. my lord.
decision whether we uphold the death sentence or we
Because
reduce it.
first, here, they must, conviction must be upheld.
Yes,
Then we'll come, this honorable court will come to the
Yes.
sentencing part,
sentencing part.
whether it is
Yes.
rarest of rare case
So,
or life.
yes, so therefore, first of all, we have to see
The evidence.
evidence first.
It connects whether both the accused or not.
Yes, correct. So maybe once we read the evidence,
Absolutely.
so
Then
it will be applicable for all the
For,
cases,
yes, ma'am.
for three of, for two only, na?
Yes, ma'am.
Moinul and Salimuddin.
Salimuddin,
These are the two accused.
actually.
So then let us read about this. What is the complaint? FIR?
Evidence.
Page 4.
Madam, Mr. Munir is also engaged in one case, so he is well prepared with his evidence part, madam. So that's all.
Leonard friend may read out the evidence part.
Yes, we'll
Summarize
just-
without,
Ah.
while making submissions. Because his pronunciation is very good.
No, we may not, one may not read the entire, we also go through. If we
Yes.
have some difficulty, we'll ask you.
Because
Otherwise, only can highlight.
my lord, actually, just giving the backdrop of the case for your lordship better understanding of the matter, my lord. Here, there are three witnesses who saw one incident, that is the deceased being hit by the umbrella and all this thing. There was a fighting. Soon thereafter, my lord, the dead body was found, my lord. Because there is no eyewitness, except eyewitness that there was a tussle between the deceased and this one of the accused person, my lord.
Selim.
Sorry.
Accused Selim. PW 2 and 3 saw the accused Selim assaulting with an umbrella the deceased.
Is it daytime or nighttime, evening?
It was in the
It's a
day,
secluded place, my lord.
3 o'clock.
No people were there, my lord. In a jungle.
3 o'clock.
2 and 3, huh?
Because their charges are 3 heads, my lord. That your lordship will kindly understand. 302 is the charge with 34, 376A with 34, and 201 with 34, my lord. Charge is probably at page 7. So, 8. The charge order.
PW 2 and 3 are child witness. And PW 3 is acquainted with the accused Selim.
If your lordship will
He
kindly
used to
look into page 7, my lord, the charge head is given there. Your lordship will understand the very basis of the case, my lord. The order is at page 8, my lord, and the charge head is given at page 7. Date, time, everything. That, shall I read, my lord?
What will that, we'll just, will dictate the basic facts.
Yes, ma'am.
And if you think that we have missed out
Sure,
anything,
ma'am.
then that will be better.
Yes, ma'am.
It will
Sure,
be
as
better.
your lordship, please.
Nico, the present reference arises out of the conviction and the sentencing of the appellant, sentencing of the accused. What is that sentence, page?
The judgment part, my lord.
Yes. 175. And
It
the
starts, my lord, because sentencing was pronounced on a separate date, my lord.
Ah.
And it starts, my lord, from 170, I believe. my lord.
Sentenced and convicted by convicted the Moinul Haq of offense punishable under section 302 IPC,
77.
201 IPC, 376.
Yes, ma'am.
Convicted the convicted Moinul Haq under section 201/302/376 AIPC. And and was sentenced to death for the offense for the aforesaid offences under section 302 IPC and the 376 AIPC. To be hung by neck till his death.
160. 160.
The genesis of the case is the Azhar filed by the husband, I think, the deceased, by the husband of the deceased on 1/6/2017, 31/5/2017,
31/5/2017.
alleging that while his wife was serving as a headmistress of Sangju Rai Ilasi Diori Lower Primary School of Jamunamukh area on the north bank of Kopli River, he was informed by one Torun Bordoloi over phone that the bag of his wife, Ornomai Bora, was lying on the bank of the river.
Ormoni.
Ornamai.
Ornamai.
Ornamai Bora
Bora.
was lying on the bank of the river and her whereabouts was not known. And after he got information later that a dead body was found floating at some distance downstream the river, which was suspected to be her wife's body, his wife's body. Whereupon he proceeded to the place of recovery of a dead body and identified it to be his wife. He accordingly filed a complaint stating that while she was returning home after her school, some miscreants taking advantage of absence of the people en route killed her on the northern bank of the river and threw the dead body into the river. Based on the aforesaid complaint lodged, an FIR, the police case being Jamunamukh PS case number 52/2007 under section 302/201 IPC was registered and investigation launched. The police, after conducting necessary investigation and collecting a recording evidence of witnesses, relevant witnesses, and collecting the evidences.
My lord, one thing I have to point out. The police received the information and made a ZD entry. Subsequently, this affair was received and registered.
Okay, uske pehle likho. On receipt of such information, the police made an GD entry, general diary entry, and thereafter the FIR was registered. Next one, then the necessary investigation was launched, recording the evidence of the relevant witnesses, and the investigating authority collected the evidences, relevant evidences, and accordingly two persons, namely two persons, no, what is the charge? Two persons, namely
Yes.
Moinul Haq and Salemuddin were charged of committing offense punishable under section 302/34 IPC, 201/34 IPC, and 376 capital A 34 IPC. The concerned session judge Huh? There's the additional session that was there. The concerned addition, the trial court, after taking cognizance, framed charge against the aforesaid two persons and the trial comments. After both of them pleaded not guilty, not guilty, not guilty. Next para. In course of the trial, the prosecution examined as many as 19 witnesses.
3 DW.
The defense examined 3 witnesses in the defense. They were also examined under section, the accused were also examined under section 313 CRPC. In the 313, did they say anything?
No, they denied, my lord.
And in the same examined under same where they denied all the allegations made against them in course of the trial, taking the plea that they were innocent and they were ignorant of the said crime. The learned trial court, the learned additional district and session judge FTC Hojai Shankardev, after considering, after appreciating evidence on record, held that the charges against them under aforesaid sections 302, 201, 376A IPC read with 34 were proved beyond reasonable doubt.
There lies one catch, my lord. 34 is not there, my
Oh,
lord.
not there.
No.
Okay. Were proved beyond reasonable
32
doubt.
can be deleted.
Okay, 34 deleted. The charges against 304, 302, 302, 201, 376A were proved again beyond against them beyond reasonable doubt and proceeded to sentence the sentence sentence the accused accused Moinul Haq to death, considering the gravity of the offense, considering the heinousness of the offense proved against him, and sentenced the other accused, Salem,
Elias Salim.
So for
Salemuddin, huh?
Sarji is concerned, my lord, 34 is there.
was sentenced to undergo imprisonment for life.
34 charge is there, my lord.
34 charge is there.
Third
At
read,
page
third-
7.
third
Page
read,
7 of the
Page
paper.
7.
Your lordship.
No, page 175, convicted under section 201, 302, 376A IPC. 34 is not mentioned.
Yes.
I
30
pointed it out what is on record, my lord. My duty.
It is not mentioned in the, though they were charged,
They were charged.
but then conviction at 34
That's
is
a catch
missing.
on it.
Full stop.
Conviction.
And accordingly was sentenced to undergo imprisonment for life for the same offense. It is against the capital punishment awarded to Moinul Haq that the present reference has been made as required under the law. We have accordingly heard the other appeal preferred by Salemuddin, the other
My lord,
co-accused.
actually, the other accused, my lord, he was leniently deal because for him 376 was not applied, my lord.
76 was not applied,
Not convicted, my lord.
not convicted.
Page 174, my lord. Para 70, my lord. The 71 is.
Salemuddin is sentenced to undergo 302, 201. Okay, okay. Acha, so then the other accused Salemuddin,
He in 3 sections, my lord.
okay, was however convicted under section 302, 201 of and the 302
Yes.
IPC
IPC.
and sentenced to undergo rigorous imprisonment for life.
Leniency.
Without the benefit of parole or remission, thus to remain in custody throughout his life. So stop. Then next, that is even present reference has arisen. The other and the other arisen out of sentencing of the death capital sentence awarded to Moinul Haq. The other appeal filed by the other co-accused Salimuddin, registered as Krill AJ 71, are also heard together as these appeals related to the same evidence, same judgment and order.
Probably also the criminal appeal filed by the informant, my lord, 322 of 2019, madam.
Okay.
It's up to your lordship.
Okay. Now we'll also hear that. We have also noted that the Bimol Bora is the complainant.
Yes.
The complainant, Bimol Bora, the husband of the deceased, also filed an appeal, which is registered as Krill A322 of 2019 for enhancement of the sentence
Of Salimuddin.
of Salimuddin to date of capital punishment is awarded to Moinul Haq
Right.
on the plea that they were involved in the same incident and were responsible, he was also equally responsible for the gruesome death, rape and death of the deceased. Also, since rape is involved, I think there is some guideline that if it is a rape, then it should be live streamed. So I think is there, guideline is there. Huh? No, this is not POCSO. Because yes, these are because we have to go by that. The live streaming means the universe is watching.
Yes.
And will be discussing the evidence,
Absolutely.
which may be very gruesome also. And
Disclosing the name of the victim is an
name of
offense.
victim
my lord.
also, yes.
I think it is there, my lord.
Then this, I think, as per the our rules, then we stop the live streaming then. Since the live streaming is discontinued, since the appeal which we are hearing involves offense under 376 of the IPC.